complete in this matter, my lords. I am for the respondent number 8. The petitioner is enjoying a stay since 2023. My lords may kindly fix a date for hearing in this matter.
We'll see.
My lord, the writ appeal was last listed in the month of June. It was directed to be listed in July, but not listed. I'm requesting any day next week, my lords. There is an urgency in the matter. The petitioners were working in a branch of IRDA, my lords. Whether they are to be treated
Give
as
your slip, we'll see from the file and then.
obliged, my lord.
My lords, 2 weeks before it listed as 52 items, but reached only 51. Since then, it was not posted, my lords. 2 weeks back, my lords, 52 number it listed and reached only till 51. It is not listed since then, my lords.
Take this slip, list it in the November.
My lords, kindly,
First week,
writ
November.
appeal number 797 of 2025, my lord. In this matter, the writ appeal is filed with condoned delay petition by the GHMC, and this honorable court directed to post the matter 2 weeks thereafter, my lord, in the month of July, my lord. Kindly, it may be taken up, my lord, in next week, my lord.
Give your slip.
Yes, my lord.
My lords, I appear for respondent number 3, my lords. The other connected matter was posted to 18th, my lords, 18th of October. Lords may kindly tag along with that matter.
18th October is a holiday. Give the other case number, we'll list it along with
I
it.
will pass on the number.
What is the other WA number?
1106, my lord.
1106.
Yes, my lord.
List it along.
My lord, I am appearing for
Wait,
With petitioner,
My lord,
appearing
I
for
would
this.
like to make one small submission, my lord.
Huh?
I would like to make. I'm appearing for respondents, my lord. I'm representing T. Koteshwar Rao. In item number 2, my lord.
yes, yes.
I'm appearing for respondents, my lord. I'm representing T. Koteshwar Rao. A senior colleague has undergone cataract surgery and is not supposed to expose to sunlight for 3 to 4 days, my lord. Some date may be given in the next week.
There is an urgency in the matter. We'll be requesting for a stay of the
My
operation
lord.
of the impugned order. My lord, in this case, what has happened is the respondents were initially engaged, my lord.
Is
as-
there any contempt pending?
No, as yet,
My lord.
my instructions are no
So
contempt
then
is
we
pending.
take it up after the other side counsel is.
My lord, before
Wait.
that, I would like to make one submission, my lord. In this appeal, appellants are mainly relying upon a settlement of year 2016,
So
my
don't
lord.
argue on merits. You want time, we can fix it on some other date.
Yes, my lord.
Meanwhile, don't press any contempt.
Yes,
That
my,
much undertaking that you do.
yes, my lord.
My lord,
List it in the last week on some date, on the ground of cataract operation. Then counsel for the respondent.
my lord may give a specific date, my lord, because
I've given a specific date.
please.
I beg to represent me, lord. IA 1 of 2025, my lord, which is delay of 239 days.
Other side appearing.
The matter arise questioning
Sir,
the.
this is that. How is it writ petition maintainable?
That was the question which was raised by the respondent. The writ is not maintainable, and that was not considered by the learned single
Writ
judge.
petitioner has appeared.
Your name is printed, but the counsel who was appearing other side, Lordship may order notice, will serve the notice.
Issue notice on the delay condonation application, suspension matter, and also the main memo of appeal.
Oblige, your lords.
May I please spell? May I please spell also? My lords, agreed by the orders of the learned court, my lord.
How much is the delay?
My lord, the delay is of 93 days, my lord.
200.
In fact, my lord, we have also issued
200. You are for?
Respondent, Milord. I am objecting for continuation of delay, Milord. This writ appeal has been filed, Milord, to circumvent the contempt proceeding, Milord. The contempt proceeding going on, and they have to implement the order, Milord. That's why.
Understood. So you object, you want to file an objection to the delay?
Yes, Milord. Yes, Milord.
Then
My lord.
file it, file it within 1 week.
Yes, Milord.
my lord.
Meanwhile, don't press the contempt there.
Yes, Milord. Yes.
My lords, that may be absurd, my lord, because we are under the pressure of
Undertakes
contempt.
not to press the contempt.
Obliged, my lords.
Give a date after 1 week.
Obliged, my lords.
Milord, one submission, small submission. Milord, I am pressing into the contempt on the basis of Supreme Court judgment stating that the order must be in consonance with the High Court order. They cannot pass as they wish, Milord. That is the, they have considered,
For
they
the
have
time-
rejected, Milord.
Honorary.
As you said, you will not be pressing till we take up the delay condonation matter. We are giving a date after 1 week.
Much.
In fact, my lords, may I submit only one point, my lord.
You
Day
also
before
don't-
yesterday, we have
Strict submit.
Don't
Much.
mix up.
obliged, my lords.
Sometimes
I'm
more
obliged, my
submission
lords.
leads to more problems.
Lordship, the writ petitioner is a MSME unit dealing in the manufacturing of different
Whether your
types of.
refund has been rejected.
No, we have made a requisition letter on 3rd September 2025 claiming the refund of the excess tax amount paid.
Representation.
Representations won't make any.
But as
You
per
have to
the
file in
RFD,
a-
RFD, one application has to be made under
File
Rule
in a
89.
proper format, RFD 01.
Yes, my lord, under Rule 89.
Lordship, actually, section 54 says for claiming the excess payments is the limitation is 2 years. So this was the matter pertaining to the December 2022. So the limitation, statutory limitation, is not available to the writ petitioner under section 54 of the GST Act.
But in any case, that plea can only be raised and considered when you file it in a proper format. You file your application in the proper format. Withdraw this writ petition and file.
Yes, with a liberty to file the.
Liberty to file application in proper GST form, GST DRC.
RFD 1, my lord.
Sorry, RFD 01 for seeking refund before the competent authority. Stop. Permission is granted. Liberty is granted.
Obliged.
May it please your lordship. In the present writ petition, may it please your lordship.
Decide his appeal.
6 months, my lord, because it's a faceless, my lord. I'll have
It's
to
since
intimate it to them, my lord.
2019, my lord. Since 2019, this matter has been held before
You
the.
have come before us today only. So,
That's because we have been constantly requesting the
so
appellate authority.
we fix a time frame for them.
6 months, my lord, because
6
it's a
months
face-
is too
yes.
much now. 4 months.
My lord,
6 months would be advisable, my lord, because it's a faceless one, my lord, and we have to send it to the faceless authority and do it. That is the only difficulty. Else, my lord, they would have
My lord.
again come up with some other petition.
my
5
lord,
months.
if I may, my only request is since 2023, we have said that we have completed giving our submission. So there's no further 6 months that
In
is
fact,
needed.
their letters, wherein,
And
my lord,
all
they have
the
not even
notices-
appeared for their.
Within a period
My,
of
my
time.
lord, just if I may just complete, in all the notices, in the annexures, wherein they have to ask for further submission or what is it that they specifically require, they've not mentioned anything in all the notices. All I'm saying is consider my submission and dispose it off, probably in the next 2 weeks. It's been more than 6 years, my lord.
Petitioner has been compelled to prefer the writ petition as his appeal preferred in the year 2019 against Caesar. Appeal is directed against which order?
The
Against the
assessment order
assessment order.
P1, which is passed on
Against the
31st December.
assessment order dated so and so. P1 has not yet been decided despite submissions made way back in 2023 itself. Stop. Learned Counsel for the department submits that if so directed, the appeal would be decided within a reasonable time as may be stipulated by this court. In view of the aforesaid limited grievance of the petitioner, the writ petition is disposed of with a direction to the appellate authority,
The fourth respondent.
fourth respondent, to decide the appeal within a as expeditiously within a period of 5 months from the date of receipt of copy of this order.
Obliged.
My name is wrongly printed in this registry may be directed. Delete my name.
Obliged.
With your Lordship's kind permission. Your Lordship, this petition is a political party, complied all conditions and procedures. In fact, the Election Commission, State Election issued 38/2025 to make a paper publication after verification. We made a paper publication submitted on 22/9. With in spite that, 50th in respect of 20 days, they are not issuing gazette and otherwise we will not be able to participate in the local body elections. Lordship may kindly see.
Just, yes.
Subsequent to the paper publication on 22nd September, 24th minute, we have issued a notification freezing the symbols insofar as this present local body elections are concerned. On 24th September.
Freezing the...
With regard to the identifying the recognized parties and the symbols. Now to allot a fresh symbol to him, we have to undertake that exercise and recognize that party as a political party. It may not be happening now in view of the now present notification which is there for the local body elections.
They can even consider without symbol, free symbol, this time. At least my party may be recognized. Symbol on waveforms will not be insisting for this part of common symbol for next time. But otherwise, will be deprived, my lordship. They can do their exercise as per the rule 7 of their own rules to notify as a party. Symbols they may not give this time. Without symbol also.
You have asked for a common symbol which was already allotted to some other party.
We have not asked for.
And registration is also not undertaken because the exercise is after the objections are received, we have to have a public hearing. Whether this party can be registered under any objections are there. Thereafter only we will undertake that exercise. Here only on 22nd September that publication is done. That period has also not expired so far.
That paper publication?
Yes. 21st September we made paper publication. 22 September we submitted that publication. They have to issue immediately gazette.
After paper publication and within 15 days if there is no objection.
Yes, my lordship.
So that period is still not over.
Not
over my lordship.
And both of you step.
And the State Election Commission also is required to publish in the Gazette with regard to this paper publication that and also by newspapers. That exercise website. That exercise is still to be undertaken.
Then it's a premature writ petition.
My humble submission is, my lordship, 21 we made a paper publication. Now it's 15 days, my lordship. No objections were received till date. They can proceed for gazette. 15 days are over, my lordship. 21st September we made a gazette notification. 9 days and 15 days.
It's not automatic. There are other procedures to be followed.
Yes, at least gazette, my lordship.
15 days is a minimum timeline prescribed.
Yes, my lordship.
Now, the complications which the learned senior counsel is pointing out,
yes,
they also have to be dealt with or met.
Yes, my lordship.
So, I mean, it's not a simpliciter that asks them and declare them as a political party and give them a symbol. And this is basically an act of the commission. The court comes into picture in a very limited sense.
My humble submission is they may act upon as per 7(2) of their regulations. That's it, my lordship. 15 days
can
is
only
now
say act in accordance with law.
Yes.
7(2) rules. 15 days is over. Now at least, now 15 days, now we are on 6th.
It is not that after 16th day I will issue the registration. That is not so. We may wait for some time also.
It's not the 15 days timeline is not like a mandatory that the moment it comes in to an end, they have to register you as a political party.
At least as expeditiously, my lordship. 7(2), your lordship may kindly consider.
Okay.
One second.
Rule देखिए. Publication is in 2 newspapers or only one?
We made in 2 minutes, 2 mandatory. 7-1, as per 7-1, 2 newspapers.
So one English and one Telugu.
Yes, Milord. We made it, Milord. Page 20, I submitted, Milord. The newspaper. 16, page 16 and page 18, Milord.
You take 7-1.
Yes, page 16, Milord. Yes, Milord. 7-1, as per 7-1.
The requirement is in 2 widely circulated daily newspapers, one of which shall be in Telugu.
Yes, my lordship. Telugu, yes, my lordship. Page 16, your lordship, in Varta. Page 16, your lordship. Varta. And page 18, your lordship, in Swatanta Bharat Hindi. English translation, English notification in page 18, your lordship. I can only pray for expeditious consideration, your lordship. If the elections were not at immediately, they wouldn't have pressed, my lordship. I would have waited definitely. Only because of this exigency, I had to approach this court. The party is already registered with the Central Election Commission in 23 itself. Page 20, your lordship. 23 registration. The Election Commission of India.
You have also complied with the requirement under 8C.
Yes, 8C. Yes, my lordship. After, my lordship, with regard to Election Commission of India, we have been complying, my lordship. There is no complaints about
No.
it. After
8C,
registration.
8C.
Yes, your lordship. Maintain accounts and the,
In case of political parties registered with ECI,
yes, my lordship.
the copy of audited annual accounts and income tax returns, if any,
Yes, your lordship. We filed all the entire material with the along with
the
the,
state,
we filed along with the EC, my lordship.
the state election.
Yes, your lordship. Entire bunch, my lordship, were filed with all the accounts, details, everything, my lordship. There's no complaint or there's no response from the
time
commission.
period for the complaint is hardly over. That is it.
We have not
just
even
ago.
undertaken the process after the period is over.
I wouldn't have been pressed, my lordship, only because this election has come. Otherwise, I wouldn't have immediately approached this. Otherwise, I wouldn't
They
have.
knew that elections are due for last 22 months.
Only
Not
30,
now.
only 30th I was directed by the election commission to submit. Otherwise, 30th August. Within immediately we may have gathered money 20th, 20 days. At least only considerations, let them examine as process expeditiously as possible. That's only I can pray, my lordship. As per. As per. Some period.
So consider his application in accordance with law.
Yes, in accordance with the order 2018 and Lord may not fix any time frame because
No, we are not going to.
As expeditiously as possible. That's the only I can pray, my lordship. Otherwise, I wouldn't have I need not anymore. So as to just to
Petitioner has approached this court alleging that the first respondent has not yet registered the uh, registered it as a political party and not allotted a common symbol to participate in the forthcoming Panchayat Raj local body elections in the state of Telangana in pursuance of the application made by the petitioner on 21st August 25 and 22nd September 25, and also to further direct the first respondent to register it as a political party and allot a common symbol to participate in the local body elections, for which, according to him, a schedule has been issued on 29 September 2025. Stop. According to the petitioner, in compliance of the provisions of the Registration of Political Parties and Allotment of Symbols Order 2018, as amended up to 7 December 2023, paper publication has been made on 21st September 2025 in two newspapers, one English and one Telugu. Stop. The period of 15 days has also expired after the paper publication. Therefore, the respondent number one has not yet acted upon its application and stop. Therefore, petitioner has been compelled to approach this court. Stop. The senior counsel for the respondent commission submits that the commission has to process the application as per the provisions of the order of 2018. Stop. Petitioner cannot compel the commission to immediately register it and allot a common symbol unless all statutory requirements are satisfied. Stop. It is submitted that the petition is otherwise also premature. Stop. Having regard to the facts and circumstances noted above, and without commenting on the procedure required, without commenting upon the merits of the case of the parties, the writ petition is disposed of with a observation that the respondent commission would consider the application of the petitioner and process it in accordance with law in a reasonable time. Stop.
The newspaper is, may I submit the publication is in English, one word. Paper is Hindi. That's only
Hindi.
Newspaper is Hindi, but
Hindi and Telugu.
Yes, Your Lordship.
Hindi and Telugu.
May I request for CC today, Your Lordship?
You'll get that.
Much obliged.
Keep this along with your compilations. These are useful. There are two in that
But my registration, GST registration is cancelled without following the procedure specified in Rule 21A and also Rule 25 of the GST rules, and also in violation of the principles of natural justice on many counts, my lord. Hence, I request your lordships
Who is the other side? CGST or state tax?
CGST, my lord.
Okay.
My lord, except filing one particular communication, my friend has not filed any other documents to show what is the present status with respect to his registration. He is only at Exhibit 2, which is the second document at page 24, he is only showing one letter written by the Assistant Commissioner Anti-Evasion to the concerned jurisdictional officer saying that the petitioner firm is non-existent on inspection and therefore the electronic credit ledger may be blocked for the proceedings to be completed. So my lord, without filing any document, he straight away come to this court, because if he is aggrieved by the blocking of the electronic credit ledger, that's only a protective measure. He can always go back to the officer with documents to submit that it is an existing firm and show proof. My lord, without taking those remedies, he straight away come for a writ petition, is my humble submission.
Milord, I'm sorry, Milord. I am not aggrieved of the blocking of electronic credit ledger. Nowhere I have sought any relief on that. I am only on the ground that my GST registration is cancelled without following the principles of natural justice and without following the Rule 21A and Rule 25 of the GST rules. There are many other grounds, Milord, which I may not press as of now. Milord, kindly see at page 20. At page 20, Milord.
Yes.
Milord, kindly see at the end. It is signed by DS Goods and Services Network instead of an officer created under the Act. Milord, in the similar situation, in the similar, exactly the same facts in which I argued before this Honorable High Court, the relevant order is at page 30, at 20, at page 33, wherein this Honorable High Court had set aside the orders of the lower authorities and allowed them to pass fresh orders. Lord, kindly see at page 33.
So your contention is that
let him follow the procedure.
The notice has not been issued by any proper officer nor digitally signed.
That is one ground, Milord. The another ground, though it is titled as Form GST REG 31, the proper form, it is not, the contents is exactly related to Form GST REG 20, REG 17, Milord. Kindly see, I have given the pro forma of Form REG 17 at page 32, Milord. This content of this form is adopted in Form REG 31 and orders are passed conveniently to overlook one important jurisdictional fact for cancellation of registration. The jurisdictional fact is an immediate threat to the revenue of the government. To avoid this particular fact, jurisdictional fact, he says this is Form 31, but the entire content is Form 17.
Does it make any difference?
Yes, Milord. In Form REG 31, elaborate procedure is specified, including the jurisdictional fact of suspension of the GST registration. Kindly see page 30.
The jurisdictional fact to issue a notice for cancellation is indicated in the notice.
Not cancellation, Milord. I am on suspension.
Show cause notice for cancellation of registration.
Yes, Milord. This is but though it is titled as show cause notice.
This is at page 20.
Yes, Milord. Kindly see at the last line.
Where is your reply to this?
No, Milord. I have not given reply.
My lord, even the papers that are served on me, my lord, none of it matches with what my friend is referring to. I have the same copy of writ petition, page 20, I don't have what he's referring to.
Just show it to the learned counsel. This is a serious thing.
Maybe he is referring to another writ petition filed by the same dealer.
Let him.
Yes, my lord, it could be, that could be one reason, because it is the same writ petitioner. My lord, the lordship may have this next week, my lord. I do not know with respect to the facts of this case is concerned. I believe he has filed on the same writ petitioner, the same counsel. There is another writ petition that is served on me for today.
For a different cause.
For a different cause, my lord. That is numbered as 30568.
New matter.
That is another issue, another subject.
No, whether it has been taken up earlier.
No, my lord, new matter.
It's a new matter, my lord.
So let both of them be listed.
Very
You
well.
have served copy upon him only in that
Yes,
case.
yes, my lord, numbered also.
Let the both matters come
Let
together.
both matters come together.
Lord, it's only submission, my humble submission
अब
is
उसमें क्या दिक्कत
GSC registration.
सब बात पे जवाब देना जरूरी नहीं है. Let WP, what is the other matter
30568.
of 25,
Yes,
which relates to the same petitioner,
same petition.
but for a different cause
Different
of
cause.
action,
Yes, yes.
be also listed along with the present writ petition on Friday?
Yes, my lord.
Very well.
Actually, 30370, which is listed now, it is fairly covered matter, my lord.
So let him also have the file with him. इस फैन को जरा बंद करवाइए तो इधर का साहब का चला दीजिए, हमको कोई दिक्कत नहीं. मेरा वाला. Yes.
Yes, may I please, my lord?
Yes.
My lord, by way of this repetition, I am seeking the revocation of cancellation of my registration, which is cancelled due to non-filing of returns.
Appeal also dismissed.
Yes, my lord, not on merits, my lord, because of delay.
13.8, my lord, is the order of the cancellation. He preferred the my lord after 1 year. And only ground that he has taken is that there is some ill health, my lord. That too, my lord, after passing of the order, two months thereafter.
Cancel, instead of preferring an appeal, he could have preferred an application for revocation.
Revocation immediately thereafter, my lord, because
The appeal
order-
is dismissed by the same authority or the commissioner?
my lord, appellate joint
No,
commission.
appellate authority is different from the
No,
commissioner.
yes.
Let him file a revocation application.
Yes, but the period of 272 days also.
That we understand. There are peculiar situations which we are coming across. So
I'll leave it to Lord.
Similar order passed by your lordship's order at exhibit number
No.
P8840.
That case is different, my lord, where
No.
all the tax dues, my lord, were already cleared and produced the proof of the same. Therefore, your lordships have entertained that and directed the commissioner, my lord, to entertain application for revocation. Here we do not know what are the dues that are.
No dues are, my lord. But I will undertake to consequent to the returns, whatever the late fees and interest, I will ready to pay, my lord.
where is the order of cancellation?
That is at page number
26, my lord.
Petitioners. Third counsel for the parties. Petitioners GST registration was cancelled with effect from 31st December 2023 by impugned order at page 26.
Yes, madam.
Yes, ma'am.
Dated 13 September 24 and exhibit P4, annexure P4 in form GST REG 19 issued under Rule 22(3). On the ground that the petitioner had failed to furnish returns for the prescribed period in contravention of the provisions of section 29(2)(c). Stub. Petitioner, instead of preferring an application for revocation of his suspension before
The same commissioner,
the
assistant
same
commissioner,
authority,
same authority.
within prescribed time,
Yes, within
or
90
the
days.
higher authority within the extended period of time in terms of Rule 22,
Rule 22, Rule 23, that is revocation is Rule 23.
23,
2, subclause 2.
subclause 2, chose to prefer an appeal, belated appeal, which has been rejected by the impugned order dated 29 September 2025. Stop. The counsel for the petitioner submits that there are no outstanding dues.
Yes, my lord.
Stop. That will have to be satisfied. Petitioner has therefore been compelled to approach this court. Petitioner had sought to explain the delay on grounds of illness by enclosing medical certificates with the memo of appeal in form APL 01. Stop. Learned counsel for the state submits that the appeal has been rejected on grounds of delay. Stop. It is not clear from the pleadings as to whether there are outstanding dues, tax dues against the petitioner, which in any case he has to deposit before any such request is to be entertained by the competent authority under Rule 22 to 3.
Rule 23(2) subclause.
23(2). Stop. He also points out to the timeline prescribed under Rule 23(2) for approaching the Commissioner of Taxes. Stop. However, he submits that this court may pass appropriate orders as may deem fit in the facts of the case. Stop. Having considered the submission of learned counsel for the parties, this court, it appears that the petitioner, instead of approaching the proper officer or the next higher officer in terms of Rule 23, preferred an appeal which was delayed. Stop. The timeline for approaching the Commissioner of Taxes is also appears to have crossed. Stop. Be that as it may, since the petitioner is inclined to approach the competent authority in terms of Rule 23(2), liberty is granted to him to do so for revocation of the registration, cancellation of his registration within a period of 2 weeks from today. In case such an application is made, the proper authority, the competent authority in terms of Rule 23(2) would consider his request in accordance with law. Needless to say that petitioner would be required to pay any outstanding tax dues which are pending, which are due against him.
My lords may say rule 23, 23(1) for them to approach, 23(2) for passing order.
23(1).
Lords may just say rule 23.
23(1).
Much obliged.
Item
My lords,
14,
Shaukas
14
notice is
and
answered.
21, my lord, or unsigned, it may be.
14 and 21.
Yes, my lord. Posted after, my lord, now.
Which is the next date when
November
we are?
14th.
18th.
November 18th, I'm sorry.
18th.
Oh, bless.
Both 14 and
21.
21.
November 8th.
Huh?
November 8th is the auction.
18 November.
Yes.
Here again, cancellation of registration.
Yes, my lord. Same grounds, my lord, without following the procedure specified for GST registration cancellation under Rule 21A and Rule 25, and in violation of the principles of natural justice. What all I am submitting to your lordship is, kindly let them follow the procedure specified in the relevant law. They are not permitted to trample the procedures.
Which is the notice?
Lord, at page 21, my lord. Lord, once again here, the suspension is ordered in form GST REG 17 instead of form GST REG 31 under Rule 21A of the GST rules. And the contents of form GST REG 17 and 31 are completely different, my lord. REG 31 allows petitioner, the taxpayers, 30 days time. And he is enjoined to give as to why the suspension is ordering for. Unlike in the cancellation, Millard, for the suspension being a serious matter, they gave larger time and they also made jurisdictional fact of as to why he is suspending the registration. Millard, kindly see this REG 17 vis-a-vis the form REG 31 at page 24, Millard. They are completely different. Rule 21 capital A, Millard, allows the petitioner, the taxpayers, to represent against the suspension within 30 days time. But whereas in the impugned REG 17 available at 21 page, is giving only 7 days time.
Yes.
Not on the face of it, the suspension application will apply where they are intending to suspend it with the show cause notice. There is no suspension that took place in this case on the show cause notice itself. Lordship may see the show cause notice. So that application will get attracted when they are going to suspend it along with the show cause notice. They have the power in the show cause notice to suspend the registration. In fact, in this case, if your Lordship were to see the show cause notice, this is at page 21. They refer to the rule 22.1 and they have not invoked their power of suspension.
We have seen that, but he is alleging that his registration has been suspended and notice has been issued in an incorrect form.
Yes, Millard. Kindly see in the page 21 at the line, at the last but one line, wherein it is stated that the registration is suspended from 17/7.
But he has the power now, merely saying other than the form. He's saying that the different form was given. The only difference is he has a longer period. So then he has to show what prejudice is caused to him.
Longer period is available in the notice for cancellation.
For suspension.
Suspension.
For suspension.
That is how much?
30 days.
30 days.
As against 30 days, 7 days time alone is given.
But we have not given him 7 days. In the instant case, by going through his pleadings, he was given a personal hearing.
Huh?
He was given a hearing. In his para 9, your Lordship may see at para 9 of his pleadings. I'll just read it out to your Lordship. Page 9. Widely alleged show cause notice GST REG 17 17 725. The respondent number 1 had also suspended GST registration with effect from 17/7. That is that date. Without mentioning the period up to such suspension would be enforced, thereby restraining the petitioner from effecting outward supplies. However, because of economic problems, no objections could be filed by the petitioner against the adverse proposals made in the said alleged show cause notice cum orders in form GST REG 17 and could not personally represent the case on 25/7. 25/7 is much later than the 7-day period. On 25, because the show cause notice 17/7, not much later, not 25/7, he had a chance to represent his case. 17/7 is the show cause notice, not? He was given a hearing on 25/7. before the respondent number 1. However, the alleged orders in form GST REG 19 dated 4/8/25 are issued cancelling the registration on 4/8/25. Retrospectively with effect from 10/6/2025, saying after examining the reply of the petitioner, he has come to the conclusion that GST registration of the petitioner is liable to be cancelled. So not he had a chance to not go before the authority and make out his case, including if he wants to say that he was given 30 days period. It is not his case. He has not gone before the authority.
So we just want to understand that why two different forms under two different rules specifying different periods to reply have been prescribed. If that is so, then in a notice for cancellation, whether he is entitled to also suspend it and give a lesser time.
Lordship's query is the logic that I understand, Lord, because when you're going to suspend it, because when a notice is issued only to subsequently cancel it, then the revenue gives a lesser time in case they fear that the ITC, etc. may be used, so it will give a lesser time. But if they're going to invoke the power on the date of the show cause notice itself, Lord, then suspending it, they're giving him a larger period of time to reply. The logic will be that because they're suspending his registration from the date of show cause notice. The moment they issue the show cause notice, on that day they suspend the registration. He can't make outward supplies. He cannot utilize ITC for payment of tax. He can only pay his tax until that date. So the logic would be, Milord, that to give the petitioner larger time. But when they are not suspending the registration, not what I would understand the drafters would have imagined that within 7 days, in case there is a threat of him utilizing his ITC or continuing any fraudulent uh, supply of goods or not, or supplying goods without receipts, etc., to stop all the business. But your lordships are right in saying, Milord, that if they prescribe 30 days, then when they are suspending it, they ought to have given him 30 days. But in the instant case, he had a chance to go before the authority. He says he received that notice. He did not go. So prejudice was not caused to him. And it's not like as if in 7 days they have cancelled it. 4/8, 17/7, Lord, the cancellation happens on 4/8. So anytime before 4/8, he could have still gone before the authority and explained his case. And now he still has the power, Lord, to file an application for revocation, taking all those grounds, including the ground that he raises now.
Lord, that would amount to jolly well cancellation of the registration, robbing of the rights of the taxpayers, Milord. When the law says it should be done in one particular manner, Milord, your lordships are fully aware that should be followed only in that manner. They cannot deviate from that. Another issue, important issue, Milord, kindly see at page 21, they relied on a document. Kindly see, Milord, for 1 minute. They relied on one particular document. The document is never supplied to me, neither at the time of suspending my registration, nor at the time of cancellation, nor even up to today. And he says that I am not prejudiced.
May I make one more? Just to, Lord, end result, Lord, the petitioner is saying that he wants to set aside the order of cancellation, and therefore that will again empower us to issue a show cause notice,
Yes,
or only the order, because the show cause notice remains. Because now what the petitioner goes back to the same authority, even in revocation.
We were just discussing that. there are two courses for the petitioner to genuinely raise these legal grounds in a writ petition and ask for an adjudication. And we are bound to deal with it adequately, subject to what you have to say on affidavit. The other course is to go for revocation, and in that case, we may direct the competent officer to decide it within a time frame. His business registration may be revoked, cancellation may be revoked, may not be revoked. That's a subsequent eventuality. But the second course would ensure that it is done within a time period.
Yes.
Here, adjudication may take more time because your counter affidavit will come and hearing, etc. some date. So, but he is insisting upon these legal points. So, without asking him whether he wants to take the second course, we'll ask you to file the counter affidavit. The petitioner has come.
Pragmatic approach.
Petitioner has come with certain technical legal points.
Yes.
We are bound to decide that, but we can't do it without the stand of the respondents. So it's the outlook of the petitioner. You file a counter affidavit. We'll have to deal with it that in such situations, which course, I mean, whether it would be proper to invoke one form, both to suspend and also to give notice to cancellation, how the prejudice is caused. So that for all times to come, the officers have a clear direction to do so. We are also conscious of the fact that it's ultimately a prejudice test.
Yes.
But still, if some specified form is prescribed, it is not followed. What are the consequences flowing out of
important
that?
thing, they violated even Rule 25. They say that they have gone to my business premises physically. If that is the case, he is required to give me, he has to upload Form REG 30 within 15 days from the date of such physical
This
inspection.
is the ingenuity of the legal mind.
That also he violated.
File
What
counter
all I am
affidavit.
asking is, let him follow the procedure. I am not asking any favor.
Let them file a counter affidavit. 3 weeks. Specific point-wise, short reply.
Much obliged.
Right.
Just after 4 weeks. Give some date.
But matter pertaining to PG medical admissions, petitioners have pursued their MBBS from the colleges situated in the state of Telangana. Now, by virtue of the explanation to the
College metle MBBS course or the intermediate?
MBBS,
Acha.
4-year M,
But as a non-local candidate.
as a non-local candidate, because they were
Yesterday we dealt with that.
yes, madam. In fact, this matter is covered by the earlier division bench judgment. Matter went to the Supreme Court. Supreme Court refused to grant interim order.
Yesterday we
Yesterday,
dealt-
Your Lordship passed an order in WP. I verified just now. 30355 of 22. I gave it number to the court officer.
So this covers your case.
Yes, madam. In fact, I appeared in the earlier last year that batch of matters.
Oh,
and the Supreme Court order, madam, I also filed it, where they refused to grant interim order.
My lord, I am appearing online, my lord. Lordship, permit me, I am not too well to, my lord. Lordship, yesterday also I made a statement. In fact, there is one WP 1893 of 2025, Learned Senior Council also appeared in that. The interim order was declined, my lord. My colleague is there, she'll pass on the order copy, my lord. That in fact, the Learned Senior Council also appeared in that. A coordinate bench of this court declined to grant any interim relief, my lord. If your lordship permits me, my lord.
My colleague is getting from the library. 5 minutes, I'll pass on the
There is,
order copy.
I may demonstrate, I don't think there is any cover. The division bench has struck down that explanation. May just draw your lordship's attention to the.
No, Mr. Sarath, this,
My lord.
the order which we passed yesterday, is it not identical to the facts of the present petitioner?
My lord, that's what I have stated, my lord, yesterday specifically, that the coordinate bench has already decided this matter. That's why I said I'll file my counter shortly. And in fact, my lord, yesterday was, I guess it was only a test case. Today, I think there are about 42 petitioners today. My lord, therefore, in fact, I not some papers also as in this matter.
It makes no difference how many candidates are before the court.
No, that is exactly I said yesterday. The effect of 371D argued in the before a coordinate bench. The bench, my lord, agreed with my argument and dismissed the interim applications. Those repetitions are
I appeared in this batch of matters. May I just draw your lordship's attention to page 96? I appeared in this batch of matters. In fact, the division bench rejected the contention of the learned advocate general that the matter is covered by another division bench order. For a moment, you let me see the issues which are framed at page 131.
Just. So all these petitioners fall in the same category?
Yes, sir. They will not be considered under explanation B2 rule.
Studied MBBS as a non-local candidate
in the state of Telangana.
Explanation B was coming against them last year.
Yes,
it was
sir.
struck down.
Yes, sir.
This year also incorporated. Yesterday this order has been passed.
And division bench, Supreme Court refused to grant an interim order.
And that also we noticed yesterday.
Yes.
Then Mr. Sarath, they will also be entitled to interim orders.
They will subject to outcome. I'll file my counter and place the. In fact, the Learned Senior Council also appeared in the subsequent petition also. So therefore.
Interim orders actually do not create precedent. So.
Yes. I'm quite conscious because the question of law was argued there. I'm making that submission.
So same order as in.
Your Honors, I may be permitted to submit the yesterday's order copy. Item 23, similar order yesterday's 3055 of 25.
You're not audible to us.
Yesterday's similar matter.
The same order is before us also.
Yeah, this is that copy only.
WP 30355 of 25.
Which,
same order is before.
Yes.
Same order. How much time for counter affidavit?
3 weeks, your lordship granted me 3 weeks time. I'll file it before that. I'm grateful. No problem.
May I please, Lord? May I please, Lord? Lords, this petition is filed against the
central tax.
Yes. Central tax, Lords.
Yes.
So, my lords, this petition is filed against the order in original passed under the GST Act, demanding a differential tax on the works contract executed by the petitioner to the government departments, lords. And the determination of tax is demanded by invoking section 74 of the Act, my lords. And a huge amount of tax has been asked to pay, even though there is no ingredients of section 74 and is against the binding circular of the CBSE, my lord, which says, my lord, which is at circular number 5, issued by the CBSE, that, my lord, at page 165 of 166. And that, my lord, in this case, my lord, the petitioner is executing work contracts to the government departments, which are, my lords, as respondents at 579, my lords. They are government departments. The contract is for, my lord, to construction of the 2-bedroom houses for the weaker sections allotment, my lord. So in the agreement entered with the petitioner by the government departments agreed to pay GST over and above the contract price, and that is fixed as 5%, my lord, in the agreements. And subsequently, when the RA bills are prepared also, the department has paid only GST of 5% to the petitioners. So petitioner and the bona fide belief that, my lord, they are liable to 5% only. The same amount has been paid to the government department.
But these arguments are not the merits of the adjudication. What
No,
is
my
the
lord,
ground for challenge in the writ
Yes,
petition?
challenging the writ petition because there is no bona fide, there is a bona fide belief that, my lord, appellant has paid 5%, whatever it is given by this.
That plea is open for being taken in an appeal.
That apart from that, my lord, my another prayer is that, my lord, because this contract is executed to the government departments and they paid only 5%, actually they are supposed to pay the differential tax amount of what is demanded in the adjudication order, my lord. For that, my lord, various high courts held that, my lord, when the contract is executed to the government and the government is not paid the amount, which is there is no dispute about the fact, that amount is to be paid to the government. So immediately whenever the DRC 07 has been issued, I approached the respondent number 579 to pay me the differential tax so that I can pay to the government. But so far there is no action from the Millard. So in such similar circumstances, Millard, whereas High Court, Millard, I given the decision of the Honorable AP High Court also, Millard, where the Honorable High Court of AP held that, Millard, the tax which is the differential tax which is not paid to the contractor is to be paid by the contracting government directly to the petitioner within 3 weeks along with interest, Millard. And also, Millard, there is another Supreme Court decision, Millard, because these issues I cannot pray before the appellate authority, Millard. So my main prayer is that, Millard, because being an indirect taxes, what is paid to me, I only pay to the government, because the government departments has agreed to pay whatever the legitimate tax.
Explain it all to the appellate authority, and if
No,
you
the
still have
appellate
a
authority-
grievance, then come.
The appellate authority cannot give any direction, Millard, to the respondent number 579 to reimburse the taxes. What is this?
That plea, that could have been a separate subject matter of writ petition.
Millard, this issue is
Not
of,
this is not involved in the same OI against OIO.
so same OIO only, Millard, because
Couldn't be taken. That's a mandamus. Writ of mandamus asking the government to reimburse the taxes. That's a separate cause of action. You could have approached the court earlier, even later. This order is an appealable order. You have so many grounds. You go in appeal, and then if you are aggrieved, come back to the
Millard,
writ court.
because when there is a without jurisdiction, Millard, I can directly approach the Honorable High Court. And also, Millard, Your Lordship may kindly see the latest judgment of the Honorable AP High Court on the same issue. Again, is the OIO only they approached the Honorable High Court. And the Honorable
The point is that the petitioner is not being rendered remediless. The writ court is always open, but come through the hierarchy.
Your Lordship may kindly see, Millard, this Supreme Court judgment on the very same issue. Your Lordship. In the case of this Surya Constructions, Millard, Your Lordship may kindly see on the very same facts, Millard. Paying the differential contract amount, Your Lordship may kindly see second page.
This is what we
The last
said.
4 lines, Millard. Equally, Millard, Your Lordship may kindly see.
This perusal of this judgment doesn't show that it was the outcome of an adjudication proceedings in the VAT Act, under the VAT Act or any other Excise Act or Service Tax Act.
In fact, it is in line with what your lordships have observed.
And also, my lords,
Please go through the appellate court. We have heard you enough.
no, my lords, last minute, just 1 minute. AP High Court judgment, I just I'll read, my lord. It's only on similar facts, my lord. Your lordship may kindly see at page
Yes,
167, my lord. Your lordship may kindly see Venkateshwar, page 167, my lord. For time being, my lord, it's only page 167. Your lordship may kindly see. This is also, my lord, the writ petition filed against the order in original determined under the Act, my lord, where, my lord, the contractor has been paid lesser amount of tax. In this case, my lord, the second parameter, in the case, the petitioner was liable to pay 16% for the work scheduled by the petitioner for the fourth respondent and 9%, my lord. So while deciding that, my lord, the rate of tax is to be paid at 18%.
That we have seen.
Page 15, your lordship may kindly see para 15, where that Honorable High Court of AP.
We have seen.
Yes. So though the petitioner is primarily liable to pay apportioned tax, the arrangement between the petitioner and fourth respondent would pay the tax to the petitioner, who would then pass it on to the GST department.
Separate. In our view, these are separate cause of action.
Yes. And Milord, against the jurisdiction, Milord, I'll kindly see, Milord, your lordship may kindly see, Milord, it's an appealable order. I'm not denying that, Milord. But Milord, invoking section 74. Your lordship may kindly see last minute.
Your last is over now.
No, only one last minute. There is only one last minute. Because without jurisdiction, I want to say, because of the government contracts, there is no intention ever to payment. Your lordship may kindly see page 165, the circular instruction given by the CBS. That is only the last case. 165. The circle. Page 166 is a portion.
Show it to the appellate authority.
No, because
this is a circular which will bind him. Show it to him.
So when the binding circular is not followed, Milord, it's amounting to.
So therefore, the appellate authority is constituted as statutory body.
Because Glasgow is one, Milord, as the Honorable Supreme Court.
That much liberty will give to you.
That not like
within
Milord,
2 weeks, file an appeal. It should
and with liberty to file separate writ petition against contractors to.
You have taken both the pleas.
Yes, because my plea mainly,
so,
Milord.
You can file a separate writ petition.
Yes, Milord. File a separate writ petition against the contracting government departments to reimburse.
Writ petition is directed against the order in original dated 7th April 25 and the summary of the order issued on 25th July.
Yes.
After so much of gap, then he'll get the benefit of this confusion. Yes. Imposing tax, interest and liability under section 74 of the GST Act for the financial period year 2019-20 and 2021. What is the total period?
Financial years
1920 to 22-23.
Yes.
Yes, Milord. Because, Milord, in this
orders
case.
are covered within that limitation.
Covered. 74, Milord.
5 years.
5 years.
Stop. Petitioner has.
Only just, Milord, and only issue, Milord. Because.
Let us dictate now. In midst of dictation, don't interrupt.
Only because, Milord, to avoid this limitation aspect.
Petitioner further seeks direction upon the respondents number 5 to 10 to pay the differential tax at the rate of 7% and 6% with effect from 18 July 22 with interest either to the petitioner or directly to the GST department, which according to the petitioner is the differential rate of tax which the department was required to reimburse to him.
Yes, Milord.
Stop. However, after some arguments, learned counsel for the petitioner seeks liberty to approach the appellate authority to raise all such grounds of law and fact as are available to him against the order in original. He also prays that petitioner may be granted liberty to raise the plea of payment of differential rate of tax against the respondent number 5 to 10 in a separate proceedings.
Yes.
Stop. Both liberties are granted. Since the DRC 07 has been issued on 25th July 2025, where after a long gap of the issuance of the order in original, the petitioner, if he files an appeal within a period of 1 week from
Last
today,
3 weeks because they have to pay
No.
pre-deposit. They have to pay pre-deposit without
10
their-
days, 10 days, with statutory deposit, the appellate authority would consider the same in accordance with law.
Obliged.
Yes.
May I please, Your Lordship?
Instead of, because there will be so much of cacophony, that's it. I'm not doing that. तो हम 5-7 जजमेंट का रिवीजन है कॉन्स्टिट्यूशन वाला उसी को इम्प्लीमेंट
May I please, Your Lordship?
Yes.
The writ petition is filed challenging the stay rejection order, my lords, dated to 30th August 2025. Due to oversight, my lords, copy of the order was not enclosed while filing the writ petition, my lords. I have filed it through memo file in the morning, my lords, in the WP USR number 109837 of 25, my lords.
They have to annex the relevant order.
I have
may take it
annexed it, my lords. If my
Let
lords
it
may
be-
permit, I may pass a copy.
Friday?
Obliged.
My name may be printed in the place of some.
Let his name be printed. Some relevant order, the relevant order, assessment order.
No, my lord, stay application order.
Stay rejection order.
Stay rejection order has not been annexed to the instant writ petition. Then counsel for the petitioner seeks time to bring it on record. Let it be placed on record by today or tomorrow. Matter be listed on Friday.
Obliged.
Obliged.
Let the name of so and so be.
May it please, Millard.
Today there is only one
Faceless Millard. Only one Millard.
Only one.
Yes. Kindly post it on 11/11 Millard.
11/11.
Yes, Millard.
Lords, the present writ petition is filed challenging the arbitrary action of the respondents in not considering the petitioner's request for registration and web options for admission into MBBS and BDS score for the year of 2025 to 2026. The petitioner could not apply due to medical bona fide medical reasons, my lords, and we have also filed the medical reports to the writ petition also, my lords. Immediately upon requiry, representations were also made, but however the respondents are not considering the same. The Honorable Supreme Court in judgment Asha.
Under which category? Acha.
B category.
You want to exercise web option in management quota B category?
B category, yes.
Mr. Sharath.
May I please, Your Honor? I'm appearing on behalf of my senior, Your Honors. Yesterday's similar matter, item 9, that order may be passed, Your Honor. In case of fresh notification for registration
Oh, my
of
lords.
web options, then
This is
only
a
the petitioner
different case,
can.
my lords, where the bona fide medical reasons are there, my lords. In
Yesterday's
honorable,
matter also the
So
same issue. The
same on
petitioner could not.
same grounds. In fact, medical reasons, technical
yes, my
reasons,
lords.
we have given a rider that in case they open up.
In this para number 30, my lords, page number 402, para number 30. 31. Having recorded, my lords, may produce.
31.
Para number 31. Having recorded that the appellant is not at fault and she pursued her rights and remedies as expeditiously as possible, we are of the considered view that the cutoff dates cannot be used as technical instrument or tool to deny admission to meritorious students. The rule of merit stands completely defeated in the facts of the present case. The appellant was a candidate placed higher in a merit list. It cannot be disputed that candidates having merit much lower to her have already been given admission to the MBBS course. The appellant had attained 832 marks, while the student who attained 821, 792, and so on marks have already been given admissions in the ESM category in the MBBS course. It is not only unfortunate but apparently unfair the appellant be denied admission. Though there can be the rarest of rare cases and exceptional circumstances where the court may have to mold the relief and make exception to the cutoff date of 30th September. But in those cases, the court must find written a finding that no fault is attributed to the candidate, that the candidate has pursued her rights and legal remedies expeditiously without any delay, and there is fault on the part of the authorities and apparent breach of the some rules and regulation principles in the process of selection and grant of admission, where denial of admission violates the right of equality and equal treatment of the candidate. Here, my lords, we have specifically stating that the petitioner is suffered from severe health issues, my lords, because of which she couldn't make the representation notes, which is an exceptional case, my lords may consider.
Same grounds we have passed this order. Same order.
My lords may
Yes, sir.
pass this exhibit P7 order, my lords. P7 has been P5 copy of WP number 25 to consider representation.
That is what
Yes.
is here.
Yes, sir. Obliged.
Ultimately वही है representation. Same ही है. Same order.
Much obliged, Your Honor.
Yes.
Obliged.
Call all of them together. 5, 6.
5,
No.
May I
24 also.
5, 6. Then
24.
24, 23, 24,
42.
and 42 and 43.
Yes.
So request that one of you lead the argument.
Yes, not today we are pressing for the interim relief.
So
I will place on before your lordships interim orders passed by the Supreme Court on this kind of issues.
And
our request is that one senior amongst you lead the argument, and one from this side.
Lordship, so
one more
in the earlier occasion, coordinate division bench of this honorable court has issued notices to file the counter
No, my lord.
on 27/9/2025.
So
Manoj,
that
they are-
means you are on this side.
Yes,
They are,
Lordship.
they are incomplete, my lord.
There are two kinds of the writ petitions, Lord. One is, Lord, the challenge is the validity of the GO 9 on the basis of the sealing and other aspects, Lord. There are other kind of writ petitions which are filed by the 2 or 3 writ petitions, Lord, where we are appearing. We say that we support the 42% subject to classification, sub-classification, categorization. Because the experience shows for the 30 years, Lord, this marginalized section people never
Very,
represented.
very well. So,
My lord, I may be permitted to make a mention, my lord. We filed the implead petitions on behalf of the backward class organizations and public representatives, my lord. Several implead petitions are there. Kindly implead my implead petition, implead my implead petition, my lord. Give 2 weeks time. We will argue the case and we file the counter, my lord.
They may not
then
supersede
senior,
us.
My lords, I would also.
We are engaging this in
My lords, I will appear for the impleading parties, my lord.
Oh,
After the
impleading
submission of the Learned Advocate General's submissions, my lord, will be. You may be kindly be given an opportunity of being heard.
basically, Learned AG, you will be leading the
Yes, my lord.
counter attack to the
Not counter attack, my lord.
counter attack.
Our grievance is, my lord, our grievance is that, my lord, your lordship may implead my petitions, my
No,
lord.
we are just trying to settle down the heat and dust so
Yes.
that we can hear it dispassionately.
Implead petitions, the implead is very important, my lord. We are filing counters and we are the aggrieved parties, my lord. They are not the aggrieved party, my lord. We are the aggrieved party. We are sufferers.
Please, please,
Several
don't-
years, we are the sufferers here.
My lord, this may not become
Let
a
the argument
political.
be started at least, and then
My lords, my lords, on 27th, we appeared. I appeared, my lords, on 27th. A house motion was moved, and the learned division bench.
so
had-
you are in 42, 43.
Yes, 42, 43, and also 24.
In fact, I was suggesting that we have not even stepped at the start block-ups. Things have started from the other side. Arguments have started.
My lord, with the permission of the bench,
No,
we will,
no, my lord.
we will dispassionately place the facts before your lordships. Then your lordships may take a call on
So,
this.
Because at the,
you will start or the learned?
I will start, my lord.
my lords, all I'm trying to.
Order for implead.
Don't worry, don't worry.
Great respect to this honorable
No,
court,
before we get confused
my primary
and
objection,
ultimate
Lordship,
outcome is defeated. So
great respect to this honorable court. with
let
great
us
concern to this honorable court,
allow
my
us to
primary objection-
control the proceedings in the manner we try and understand the issue, and we can tell all of you
My
that
primary objection that, my lord, the petitioners
You are
have
not
not been
listening.
challenged statutory provisions. They have challenged only GOs. And
all that this court will also be in a position to
What
appreciate one by one when they start the argument. So
We
please do
rely
not.
on them. I rely on statutory provisions. I don't challenge them.
Very well.
My lord, so
So amongst both
My
of you,
My lord, I just want, before my learned friend begins, I just wanted to clear the air on what happened on 27th, my lords. Apparently at the stage of mentioning, my lords wanted some clarification on that. My lords, on the 27th
Passed
of.
on a note on that, what happened.
Yes.
My friend can have a look at
Yes,
it.
because
of us
both
were
myself and Mr. J. Prabhakar appeared on that day, my lord. I appraised the
The note
court.
that I
Plus on
passed on.
that day, on that day, my lord, what happened on 27th of last, what happened was only the GO was in place. Only
My
the
lord,
GO.
prior to begin the arguments, my lord, you lordship may say, implead my implead petitions and give the opportunity, my lord. We are the aggrieved persons. They are not the aggrieved persons, my lord.
aggrieved.
We are
We
the
are
aggrieved
aggrieved.
persons. We are the sufferers in the several
They are
years.
impleeds.
First of all, you lordship may give the opportunity, and implead the petitions. We will file counters, my lord. Unnecessary, my lord. We are the aggrieved parties here, my lord. We are sufferers.
Subject.
Several years we are sufferers.
Subject to your lordship's
everything is
permission, my
going
lord.
above our head.
My lord,
How they are now they are started arguments, my lord.
Lord,
Without my
before-
petitions are ordered, without giving the opportunity, we file the counters. Give the 1 week time, my lord. We will file counters and we will argue the case. They have no any loss to them, my lord. Without it, they have no any loss.
Suppose
they are we are the sufferers. We are the sufferers. We are the aggrieved persons here.
Please, please. Suppose we dismiss their application today. Is there necessity to implead you? So please
That is the
have
case,
some-
my lord.
please
That
have
is the
some-
case, my lord. You lordship may implead.
My-
First you lordship may
In such
order implead.
circumstances, blood,
Since such circumstances, blood, I am also filed one of the.
Then it's very difficult. This way, this is very difficult.
Yes.
I understand.
Lordship may control
This
also.
way, it's very difficult. Tell the councils who are standing behind to take their seats.
Yes.
The importance of
Someone
the
be
case,
on his feet on this side, and this side. We'll hear all of you, but not this way.
Oblige.
Yes, ma'am.
Because the whole purpose will be defeated. We won't be able to appreciate and digest whatever is being argued.
Yes. Becomes too emotive.
I can understand that this might be a very serious issue for the state, but we have to decide it very dispassionately and objectively. Unless we understand or we are able to make to understand in a very peaceful manner, we can't be able to appreciate the contentions. At least this is not our style of function.
It's not. It's not practice of this subject.
That you have seen the way of working in.
Lordships, we deeply appreciate what your lordships have said, definitely. Only thing is that, my lord, the implete petitioners, I am appearing on behalf of some of the implete petitioners.
We have that
Only
in
the
mind.
consent is that,
We
my
have
lord.
that in mind. Unless we refuse you at the appropriate time, you do not have a grievance at this stage. We know that there is an implete petition.
Yes.
Persons who are the beneficiaries of this GO or whatever is under challenge, they may also like to address us. So please wait. It is their cause which they have raised. Let them first have the audience.
Listen, I can speak on behalf of instructions.
Please ask the council standing behind to take their seats. Otherwise, it becomes such a.
Yeah, my lord, before commencing the argument,
No more comments.
one small submission, my lord.
Enough of.
My lord, a small submission. As far as my impediment is concerned, we are requesting the state government to accommodate farmers in this 42%. We are not against 42%. That your lordship will take the
Let
demand.
the petitioner start.
When the
Let the
state
petitioner
is
start.
filing the affidavit or counter to these impediments and the main petition, my request is through this court is that when they did the socio-economic political survey, I want to know caste-wise how many farmers are there in each caste, whether it is SC, ST, BC, A, B, C,
We are
D,
not
E,
at all
or
able to
OBCs.
follow. Learned
So because
council,
this,
we are not
this
at all able
nation
to
has
follow.
never taken care of farmers. Thank you
Please,
very
please.
much, my lord.
My lord, the subject matter, may I begin with the kind permission? The subject matter in this,
Yes.
my lord, the subject matter in
Please
these.
take your seat.
Seats are to be, it's all become kissa kursi ka.
I think we are not in the age of where councils listen to senior council, but we'll try. Lordship.
They are saying that they are also.
Let them settle down.
No,
so
we have
that
no
can-
problem. We have no problem. We are accustomed to stand.
My lord,
Except that we disturb the
we will
proceedings.
assist your lordship. My lord, I
Yes.
apologize for the short issue in this. I'll keep it very brief, my lord. So the short issue in this batch of writ petitions is a challenge to a GO issued by the state. The GO has been issued for both Panchayat Raj and municipalities, increasing the quantum of reservations. The quantum has now gone, it's up to 67%. It has gone beyond 50%. Now, our challenge to this GO is on 4 grounds. And we have supported by President and similar interim orders passed by the Honorable Supreme Court where the 50% rule has been gone. Our first ground is that this is ultra virus, not only the constitution, but the very statute itself. The statute under which the Panchayat Raj elections and municipality elections are being held specifically says that in recognition of the Supreme Court judgment, this is not my language, the statute says, and I'll show the statute in a second, the statute says that in recognition of the Supreme Court judgments, the upper ceiling of 50% shall not be breached. That's the statute. Today, the state has issued a GO contravening their own statute. That's my first ground. My second ground is that both the two constitutional provisions, Article 243T and D, categorically state that any reservation for backward classes shall be made by the state legislature. Lordships recollects 16.4 says state by a provision. But for backward classes reservations, the constitution says state legislature by a provision. So any reservation for backward classes must necessarily trace it back to the statute. That's my second ground at all.
That ground comes from that Article 243, T6 and D6 perhaps.
I'm grateful, Manoj. I'll show that in a second. So whereas 15.4 and 16.4 say state by provision.
Public employment.
Public employment. So there Indra Sawhney said, 9-judge bench said that it can be by circular and GO as well. But when it comes to 243T, the two provisions your lordship pointed out, it says state legislature by a provision. So consequently, anything has to be traced back to the statute. That's the second ground. The third ground of attack is directly Article 141. The Honorable Supreme Court in Krishnamurthy's case specifically said that this is a 50% cannot be breached under any circumstances. The only exception they carved out is that for scheduled tribes in scheduled areas. This is the exception that they carved out. And they specifically directed state legislations to please amend your legislation to ensure that it is in accordance with the Supreme Court judgment. Our state of Telangana has amended their state legislation in accordance with the Krishnamurthy judgment. Today, the state is now issuing a GO, ignoring their own legislation where they've stood. And my last fourth ground of attack is that after Krishnamurthy, in case of Maharashtra, the Honorable Supreme Court said they propounded what is called as a triple test. That they further expounded the Krishnamurthy doctrine, and the triple test has three components. And one crucial component is that if the 50% is not complied with, no state election commission shall notify the election.
And even if you do.
And even if you do, it shall be ignored. So this is the broad framework of this. We have other grounds which can be taken up in final hearing, which is that the entire election was based on a one-man commission report. Our division bench said that before you rely on any report, it can or you cannot base it on unpublished data. So you must publish the data of the report, and that published data must be examined. Only then you can notify. That mandatory step has not been complied with. Following that,
there was a commission constituted in this state.
In this one-man commission, but it was an in-house affair.
That commission has submitted a report.
We have not seen that report.
So that was ever placed before any?
No.
It is unpublished. And so our division bench said that
GO somewhere says that the government has accepted, or
the GO says that. The GO says that.
No,
The GO says that the government has accepted it.
The government.
But
I just want to add one more. Exceptionally, this is a case where the one-man commission report has come within days of reference. I don't know if it's days or hours, because what it says is 27th February it was referred to him. March 2025, the report is given. So even the date, the GO, your lordship will see, is silent about the date on which such a report was placed.
And the final ground is that the three-judge bench in Vikas Gavli says that you can't take the entire state as a unit. Reservation necessarily has to be district specific. So the last two, lordship may take. But now in this particular case, lordship may just take the GO, impugned GO. In the compilation at page 18. Page 18 is where the GO9 has been.
GO9 is about increase of that percentage.
Percentage of reservations.
And GO41 is about?
Consequential steps.
Steps to be taken in terms of that.
But GO9 is the core.
Notification of this elections?
Election, it's my contention. As per the that election notification is not yet out, because the Panchayat Raj Act says the election has to be notified by way of a gazette. That step has not yet been taken. What has been announced so far has been an election schedule. But nonetheless, the Honorable Supreme Court has gone one step further and said that even if election notification is given, it doesn't matter. Elections cannot be held if the triple test is not compliant. All of this by way of an interim order. We want to place those interim orders for your lordship's considered view. Lordships may kindly see page 18. I just want to place the GO before your lordship.
Yes.
Well, because this is a critical, please allow me to read the critical portions. State of Telangana, which came into existence of 2nd June, was the outcome of a prolonged and determined struggle of people of Telangana to achieve the aspirations of the people. One of the cherished goals of the movement was the need for inclusive growth and equitable development, particularly of the marginalized communities. But we have no issue on this. In accordance with the constitutional mandate of equality and social justice, the state of Telangana recognizes a significant backward classes populations and is committed to promoting their welfare, inclusion, and their equitable development. We also second this. We are para 3. Whereas Article 40 of the Constitution, which enshrines one of the directive principles of state policy, lays down that states shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government, a worthy goal. Lordship may kindly, with due respect, my lord, the mischief starts at para 4, how the mischaracterization begins. Whereas Article 243D, subclause 6 of the Constitution empowers, my lord, kindly make a note, my lord, empowers the state to make any provision for reservation of seats in any panchayat or office of chairpersons at any level in favor of backward class of citizens. I'll pause here for a second, my lord. 243D, it does not empower the state to make any provision. 243D, my lord, I'll show in a second, empowers the state legislature to make a provision. So, my lord, this is the root of what I would call as the jurisdictional challenge. The state government seemed to be under the erroneous impression that the government can make a provision, where the constitution says the legislature has to make a provision. Then same error creeps in para 5 as well, whereas Article 243(6) of the Constitution empowers the state to make any provision for reservation of seats, any municipality, in favor of backward class of citizens. In the GO first read above, the government has set up dedicated commission under the chairmanship of Sri Busani Venkateshwara Rao IAS in November 2024 to conduct a contemporaneous, rigorous, empirical inquiry into the nature and implications of the backwardness for local bodies in order to specify the proportion of reservations to be provisioned. In February 2024, the government has decided to undertake a socio-economic, employment, political and caste survey, which was subsequently approved by both houses of the state legislature. Pursuant thereto, the government issued orders to conduct the SCPC survey. The survey was conducted in the state and has thrown light on the relative economic, social, education, employment and political status of different castes of the state. In the GO third read above, government appointed Sri So-and-so as a one-man commission for studying and analyzing the empirical data of the survey and other relevant data for recommending percentage of reservations of backward classes. The one-man commission submitted its report in March 2025, observing that backward classes continue to remain relatively lagging compared to their population of 56% in the state, and recommended at least 42% reservation in political representations, particularly in local bodies. Next slide. After careful considerations of the Commission's recommendations, and in view of the BC population and their inadequate political representation, the government concluded that it was necessary to revise the existing level of reservation in local bodies to 42% for their welfare and advancement. The government have accepted the recommendation for reservation to backward classes at least 42% in rural and urban local bodies in the state. Accordingly, the Telangana Backward Classes Reservations of Seats in Rural and Urban Local Bodies Bill was passed in both houses unanimously by all political parties. Government, having considered enhancement of reservations of backward class in local bodies by GO number 7, have given additional terms of reference for the dedicated commission to indicate local body-wise seats and positions for backward class at 42% as mentioned in the Telangana Backward Classes Reservation of Seats in Rural Areas and Urban Local Bodies Bill. The dedicated commission has submitted its report on 28th August 2025 by indicating the seats and positions at 42%, and the same was considered by the government. Now comes the operative part.
So this bill was passed?
It has passed, but not yet become a law.
Because it's
Not
pending.
presidential
Assent of the
governor's assent has not yet been given.
So it's not.
It's not law.
It's not.
So when was it passed in the assembly?
31st of
August.
August 25.
Oh.
31st of August.
31st August.
That bill after. Yes.
It-
31st August.
I know.
And for the assent of the Honorable Governor, it is pending.
Yeah.
Yeah.
Is there a requirement to seek the assent of the President also
He
in
has
these
done
matters?
so. No, there is. There is.
But assuming there is no, I'll take the Learned
No,
Advocate General
just
statement.
this-
Sorry.
This was a relevant input to be taken into account. So it is pending for assent for the last 6 months.
No, they'll have to also state time when it went to the governor's for a governor's assent. They are taking the date of passing of the bill. That my friend will have to give a
And
make a statement.
Houses was on 31st of August. The passage by both houses was on 31st of August.
Malat, Malat, page number 30, I have placed the bill which was present before the state legislature.
No, is there any dispute about this fact? Because
Yes,
Yes,
ma'am.
there is.
There
Yes,
is.
there is.
I'll, because page number 30, Lordship may just see it for a second. The bill for increasing the reservation in municipalities was
Yes.
introduced on 31st of August. But Malat, there are two prongs to this. Number one, whether it's in, if I take the Learned, please pass on the bill copy has been sent.
Item 5.
Item 5.
Item 5.
Manoj, but I'll take the Learned Advocate General statement, Manoj, as a responsible officer of the court. Even assuming it is sent in March, 1st of March, it is still a bill.
So far that we follow.
So therefore, what the GO has been issued by the Secretary of the Panchayat Raj, he has to follow his own statute. A bill has not yet become the law of the land.
Shall let us proceed further.
Yes, ma'am. Para 11, Malak. Government after careful examination, considering the exceptional situation in Telangana marked by its multi-dimensional backwardness of backward classes, in terms of social and political indicators, in exercise of the powers conferred upon the Constitution based on empirical evidence, legislative sanction, and judicial recognition. Lordship, my argument is on all these three prongs. And in view of the urgent necessity to ensure the welfare, empowerment, and full participation of backward classes, and to uphold the constitutional vision of equality, social justice, and inclusive growth, hereby order to provide 42% reservation of the seats and positions in local bodies in the state of Telangana. The Panchayat Raj, Urban and Rural Department, so and so, shall take necessary action in this regard. But the next GO is consequential, so I don't want to spend time on this one.
No, but this has been issued by order and in the name of the Governor of Telangana.
An order in the name of
It's formal.
Secretary to government.
Secretary, under the business rules, under the Lordship,
obviously.
Under the business rules, it has been, the Lordship may just, the relevant statute, let me come straight away to the statute, Malad. I'll show the Constitution in a second, but I want the statute is, permit me to go in the reverse order, Malad. Lordship may kindly see page 26. I've put the statute for, in the same.
Just a minute.
Constitution.
Yes, Act.
Act, Malad. I have, Lordship, I've paid page 26, I put the Act, Malad, at one.
So, this GO 9 is under challenge.
9 is under challenge.
41 is also
under challenge. 41 is a consequential steps, Malad, but Lordship may, If Lordship may kindly come to page 26.
26 of your compilation.
Compilation. Now 26 is the Panchayat Raj Act. The relevant provision was on 27. It came, my lord, by an act of 2019. I'll trace the judicial origin of this act, but the provision is, this is the statute as on the book as on today. It came by its title to 285A, special provisions in respect of reservations for the seats and offices in Gram Panchayats, Mandal Praja Parishad, Zilla Praja. It's a very unusually worded section because of the Supreme Court ruling. It came in that way. In pursuance of the judgments of the Supreme Court in India, the upper ceiling of 50% vertical reservations in favor of SC, ST, OBCs should not be breached in the context of local self-government. And accordingly, notwithstanding anything contained in 9, 17, 146, 147, 175, 176 and elsewhere in the Act, providing for reservation in favor of scheduled castes, scheduled tribes and backward classes, the seats and offices to be reserved for backward classes shall also be determined, duly keeping in view the requirement of reservation in respect of SC, STs therein, and the total number of seats / offices reserved for SC, ST and BCs shall not exceed 50% of the total number of seats, or the case may be, offices in the respective local bodies in the manner prescribed. Our first ground of challenge is that the constitutional requirement has been interpreted by Krishnamurthy in a bench of 5 judges, where they directed each of the states to please tweak your legislation to be in accordance with our judgment. The state, in compliance with the Honorable Supreme Court judgment, tweaked the legislation and put it expressly. In fact, every sentence in this statute is borrowed from the Supreme Court order. And after tweaking it and putting it, now today, the state cannot say, we will ignore our own statute. Rather, the state, the Secretary Panchayat Raj, who is responsible for administering this particular judgment and the act, cannot say, I will ignore my parent statute and give issuance to a government order in blatant breach of this. This is our first ground of challenge. Similar provision is there for the municipalities as well. What I showed is the Panchayat Raj. Lordship may kindly see the page 28, the Telangana Municipalities Act, where section 7 proviso says, provided that the total reservations shall not exceed 50% of the total number of seats of the municipality. On page 29.
This is the same act.
It's a different act. This is the previous act was the Panchayat Raj Act.
This is Panchayat Act.
This is for the Municipalities Act. The GO covers both. Provided that the reservations shall not exceed 50% of the total number of seats of the municipality.
Yes.
The bill which was sought to be passed, I stand corrected, which was passed by both houses, seeks to amend these two provisions. I've placed that bill also at page 30. The bill was introduced in the Legislative Assembly on 31st August. Sorry. Thank you.
Yes.
Page 30.
Yes.
This is a bill which was introduced, at least as per the text of the bill, on 31st August 2025. A bill further to amend the Telangana Municipalities Act 2019. It shall come into effect on the state on notification Telangana Gazette. It has not yet been notified in the Gazette till now. Page 31.
Achha, this is what you were referring to, this 31st August.
31st August.
Achha, this amendment to the Municipalities Act was placed on 31st August.
Yes.
As per the text of the bill.
And
similarly, Panchayat Raj Act also 31st August.
And passed, or it was still pending?
It was passed by the both houses of parliament, but assent, both houses of the, sorry, I'm sorry, correct, by both houses of the assembly, but not yet, assent has not yet been given by the governor. And the bill itself says it shall come into on the date notified in the Telangana Gazette. It has not yet been notified.
So this two Panchayat Raj Act and the Municipalities Act bills were placed for amendment of the corresponding sections,
Statutes.
which had limited 50%, 2019. They have been passed but not notified.
Just to supplement my learned friend and the learned AG Malad, the only section which is relevant for your lordship's present examination is 285 cap A, which my learned friend has just placed before for your lordship's concern. It is that which was sought to be amended by both the houses and which was passed. That was passed, relevant to your lordship's question, on 31st August 2025. It's only after that it is placed for the assent of the governor.
That I have followed.
Yes,
that we
Malad.
followed that.
Yes. That is the only question. So to say March and all may not be relevant. The section is relevant.
Yes.
The critical point, and I'll address it when I show the Supreme Court judgment. The critical point is that even these legislations, sorry, not legislations, the bills which have been passed by both houses, they do not say go beyond 50%. It's very minor, because Supreme Court in Maharashtra, they passed a similar law where it had become the law. Assent was given, notified. Supreme Court read down the law, says this has to be understood to mean within 50%. So even the enabling legislations only say, sorry.
Yes.
Only say that government is empowered to provide, but it does not say, it does not fix the percentage. Now,
which is that relevant provision where the amendment is proposed in these,
Lordship,
has been passed?
The
31.
37.
Page 37.
37 for Panchayat Raj and 31 for municipalities. 37 is, my lord, lordship may kindly see what my friend Mayur was referring. In the Telangana Panchayat Raj, for section 285A, the following shall be substituted, namely.
That is relevant.
Yes.
My lord, what is missing from the amended in the proposed law, I would say, the ceiling of 50% has been removed, but no reservation has been prescribed of above 50%. Because identical legislation, Maharashtra, Supreme Court read down this to say, again by way of an interim order, I'll point that this will mean below 50%. So this is the, Lordship, I just now, if I can place the Constitution before your Lordships, in the compilation itself. Lordship may kindly come to page, my Lord is aware of it, but it turns on this, 44. Page 45. Lordship, as the Lordship is well aware, if in local bodies, reservation for scheduled castes and scheduled tribes is a mandate of the law. There is no discretion. But when it comes to backward classes, the Constitution has given discretion to the state legislature. And that provision is there in page 45.
Yes.
I'm reading it slowly because the state has misconstrued this provision, as I've already pointed. Nothing in this part, clause 6, nothing in this part shall prevent the legislature of a state from making any provision for reservation of seats in any panchayat or offices of chairperson at any level in favor of backward class of citizens. But the reason why I'm emphasizing this is in the GO, they strike out the phrase legislature. The GO says that the state is empowered to make any provision.
That you read out.
So Malad, the underlying constitutional principle 243D is any reservation for backward classes must have a legislative pedigree, must have a legislative sanction. That's the principle, Malad. Similarly, same 243T as well, clause 6, identical provision. That legislature must make a provision. So in on this point, the issue of legislation has been emphasized in both the two Supreme Court. I'll just come to that when I show the rulings. But both the two Supreme Court rulings said unless it is come by way of a legislation, you cannot do it. The impugned GO on the face of it, the learned secretary who has issued the GO, without looking at the constitution, without looking at his own parent statute, looked at the bill and issued a GO assuming that the bill has become the law and used that bill to cross the Supreme Court breach. So this on the face of it, with utmost respect, I would say this is sufficient with utmost respect to stay the impugned GO, on which I'm pressing the impugned. But since the issue comes, my Lordship, may just, why the importance of this? May I just place your Lordship only 3 paragraphs of Krishnamurti, the Constitution Bench rulings, at page 48. No, find it. There is no find it. Our political reservations in our state were challenged even prior to the 73rd Amendment and the full bench ruling. My friend will refer to it. What I will focus on is on the constitutional provision and how it was understood by the Honorable Supreme Court.
Yes.
Get my notes in the
Yes.
The 243T and 243D, where the validity of these two amendments on the violation of basic structure was challenged. The matter came up before a constitution bench of 5 judges in Krishnamurti, which is at page 48. Yes. Page 58 is the issues have been framed. Para 9, page 58. Para 9, page 58. In light of the submissions that have been paraphrased in the subsequent paragraphs, the contentious issues in this case can be framed in the following manner. Whether Article 243D6 and Article 243T6 are constitutionally valid since they enable reservations in favor of backward classes for the purpose of occupying seats and chairperson positions in panchayats and municipalities respectively. I'm only concerned with that issue. Second issue, I'm not concerned about. The specifically submissions were recorded, my lord, that political reservations is not the same as reservations for under 15.4 and 16.4. Lordship may kindly come to page 72, para 60. My lord, to save time, I'm only reading the absolutely the core. Para 60. There is no doubt in our minds that excessive and disproportionate reservations provided by. I'm so sorry.
Yes, yes.
There is no doubt in our minds that excessive and disproportionate reservations provided by the state legislations can indeed be the subject matter of challenges before the courts. However, the same does not justify striking down of 243D subclause 6 and 243T subclause 6, which are constitutional provisions that enable reservations in favor of backward class workplace. So, Malak, the first principle is that if a state legislation makes excessive and disproportionate, it can specifically be challenged. Now, specifically going on to the next page, page 73, para 64, the operative portion. In the absence of explicit constitutional guidance as to the quantum of reservation in favor of backward classes in local self-government, the rule of thumb is of proportionate reservation. So the starting principle is proportionate reservation. But then comes the caveat. However, we must lay stress on the fact that the upper ceiling of 50% quantitative limitation with respect to vertical reservations in favor of SC, ST, OBCs should not be breached. Lordship may kindly note this phrase, should not be breached, because this is the identical language used by our statute as well. On the question of breaching this upper ceiling, the arguments made by petition, the rest is not relevant, but the principle here is that 50% should not be breached. I'm going to read para 65 because it's a specific contention which the state has also made in this case. Sri so-and-so has contended that since the context of local self-government is different from education and employment, 50% ceiling for vertical reservations, which was prescribed in Indira Sawhney, cannot be blindly imported since that case dealt with reservations in government jobs. It was further contended that the same decision has recognized the need for exceptional treatment in circumstances, which is evident from the following words. In short, specific contention was taken that 50% you can apply it for education and employment, but do not extend it to political reservations. Para 66. Admittedly, reservations in excess of 50% do exist in some exceptional cases when it comes to the domain of political representation. For instance, the legislative assembly, my emphasis again, the legislative assemblies of the state of Arunachal Pradesh, Nagaland, Meghalaya, Mizoram, and Sikkim have reservations that are far in excess of the 50% limit. However, such a position is the outcome of exceptional considerations in relation to those areas. Similarly, vertical reservations in excess of 50% are permissible in composition, so and so. Now, 67 is the crucial part. In the recent decision reported in Union of India versus Rakesh Kumar, this court has explained why it may be necessary to provide reservations in favor of scheduled tribes that exceed 50% of the seats in panchayats located in scheduled areas. Cannot be invoked when we are examining the quantum of reservations in favor of backward classes for the purpose of local bodies located in general areas. In such circumstances, the vertical reservations in favor of SC, ST, OBCs cannot exceed the upper limit when taken together. It's obvious that in order to adhere to this upper ceiling, some of the states may have to modify their legislation so as to reduce the quantum of the existing quota in favor of OBCs. My submission, my lord, is that our honorable state legislature has understood the Supreme Court judgment perfectly well. And since the law declared under Article 141 is binding on the state legislature, 285A was amended, and specifically they have modified the legislations in terms of the Supreme Court order and said, because of the honorable Supreme Court ruling, we will not breach the 50%. So 285A is incorporated pursuant to the dicta of the honorable Supreme Court in para 67. That's the point. The para 79 is the conclusion. Page 79, para 82, subpara 4. The upper ceiling of 50% vertical reservations for an SC, ST, OBCs should not be breached in the context of local self-government exceptions can only be made in order to safeguard the interests of scheduled tribes in the matter of their representation, so and so. So there are two principles must follow. Number one, state must tweak their legislations, and two, the exception for exceptional circumstances in case of political reservations is only for scheduled tribes. And in schedule, I'm grateful to my friend, scheduled tribes in scheduled areas. Nothing can, for BCs, the Honorable Supreme Court said this exception cannot apply. Plus, on page 80, this was a bench of 3 judges. These are the 2 judgments, my lord, and after that all are interim orders. The before this concerned the political reservation in Maharashtra state local bodies, where an act was passed. But today, at least, we are dealing with the government order. In Maharashtra, page 84, they passed a statute. Let me explain why I'm reading this ruling. Krishnamurti came in 2010. Gawali came in 2021. They have expounded Krishnamurti and said they've crystallized Krishnamurti and came up with what is called as the triple test. And the triple test has been laid out in this judgment. The reason why I'm emphasizing the triple test is because after this judgment, several states tried to do by legislation what the government is doing by way of a government order. The Supreme Court came down repeatedly and said, since you have, by way of an interim order, since you have not complied with the triple test, and I'll show what the triple test is, elections cannot go on in the manner you have notified. The rest of the elections will go on, but the excess reservation for OBCs cannot move forward. So that's the importance of this judgment. Also, may just page 84 is the challenge. They have challenged the state statute. These writ petitions under Article 32 seek a declaration that Section 12C of the Maharashtra Act, including Article 14 and 16, in addition, the validity of the notifications dated, till now, the notification as per the Panchayat Raj Act have not been issued. In this case, even the notifications were also challenged. The validity of the notifications dated 27/7 and 14/2 issued by the State Election Commission for reservation exceeding 50% in respect of Zilla Parishad so and so have been questioned, and it is prayed that same be quashed and set aside. On page 85 is a table. It's very instructive, my lord. The reservation was exceeded in some cases. In the table, if your lordships will see the 5 districts, on the right-hand column, it begins with exceed 50%. Well, in a couple of cases, it exceeded only by 1.92%. That means the total reservation was 51.92%. Our case deals with facts which are dealing with 67%. So the facts
here, it is not restricted to any district.
No.
Statewide.
Across the state.
Across.
Statewide.
So, which I'll just, that's another infirmity which Vikas Gawli found. Lordship may kindly see, it's only as low as 1.75%. The relevant, the Krishnamurti, I'm not going to read all the paragraphs where Krishnamurti was expert, but page 90, para 8.
Yes.
I'm sorry. Page 90, para 8.
Yes.
On a fair reading of the exposition in the reported decision in K. Krishnamurthy's case, what followed is that the reservations of OBC is only a statutory dispensation to be provided by state legislations, unlike the constitutional reservation regarding SC, which is linked to the proportional population. That is a very important principle, which I've already mentioned, that 243T and 243D, it needs a statutory pedigree. As regards state legislations providing for reservation of seats in respect of OBCs, it must ensure that in no case the aggregate vertical reservation in respect of SC, ST and OBCs taken together should exceed 50% of seats in the local bodies concerned. In case the constitutional reservation provided for SC and STs were to consume the entire 50% of seats in local bodies, and in some cases in scheduled areas even beyond 50%, in respect of such local bodies, the question of providing further reservations to OBCs would not arise at all. To put it differently, the quantum of reservation for OBCs ought to be, well, this is very important, local body specific, and be so provisioned to ensure that it does not exceed the quantitative limitation of vertical reservation of seats taken together. So this is fairly emphatic. There is a qualitative, which is proportional qualitative limitation, and a quantitative limitation. Now comes the crucial triple test, which page 92, para 13. Be that as it may, it is indisputable that the triple test, my lordship, I kindly request your lordships to note this phrase, triple test, required to be complied with by the state, there's a condition precedent, before reserving seats in the local bodies has not been done so far. To wit, what are the one, set up a dedicated commission to conduct contemporaneous, rigorous empirical inquiry into the nature and implications of backwardness for local bodies from the state. We have alleged in the writ petition that this was not done. I am not pressing with that point. My friend may press that point, but today I'm only focusing on 3. In any case, such reservation shall not exceed aggregate of 50% of the total seats reserved in favor of SC, ST, OBCs taken together. This is the third component of the triple test. In any case, so first there must be a rigorous empirical inquiry. Unfortunately, we are disabled from challenging it because the rigorous, so-called rigorous empirical inquiry has not been shared, has not been published. And therefore, but for the purpose of interim relief, we're emphasizing on the third prong of the, in a given local body, the space for providing reserve in favor of OBCs may be available at the time of issuing. However, that could be notified only after fulfilling the aforementioned preconditions. This is very critical. So any election notification for reservation can only be done after you fulfill the aforementioned preconditions. In Maharashtra's case, the first step was only not done. So therefore, they said, in Maharashtra's case, the first step was not done. Therefore, they said you have failed the empirical inquiry. But para 14, it goes to a different prong, and which goes to what the query which came from the bench just now. As regards section 12(2)(c) of the 1961 Act inserted in 94, the plain language does give an impression that uniform and rigid quantum of 27% needs to be set apart by way of reservation in favor of OBCs. In light of the dictum of the Constitution bench, such a rigid provision cannot be sustained, much less having uniform application to all local bodies within the state. Instead, contemporaneous empirical inquiry must be undertaken to identify the quantum of local body or local body specific. But this is the second prong of my argument. One, the triple test is you can't exceed 50% under any exceptional circumstance. The second thing is it can't be 27% generic across the state. It must be specific local body specific. The impugned GO makes it what Maharashtra did by way of a legislation. The same voice carries it in the GO, where they make it across state specific. So now it's 42%. Therefore, what consequently happened is that they page 93, they said this is the jurisdictional error, para 19. They say that even the election commission also made the same jurisdictional error in para 19. And page 99, para 27, the conclusion. This is, in conclusion, we hold that section 12(2)(c) of the Act is an enabling provision and needs to be read down to mean that it may be invoked only upon complying with the triple conditions. And para 27, as specified by the Constitution bench of this court, before I'm sorry, I'm
27.
27. I'm sorry.
Yes.
In conclusion, we hold that section 12(2)(c) of the Act is an enabling provision and needs to be read down. Needs to be read down to mean that it may be invoked only upon complying with the triple conditions as specified in the Constitution bench of this court before notifying the seats as reserved for OBC categories in the local bodies concerned. I'll pause here for a second, Manoj. On a demurrer, even tomorrow, today the state argues, and it can't, but even assuming, Manoj, that the two bills have, if the argument is that the two bills have the effect of a law, what Vikas Gavli says is that even that law in Maharashtra, we will read down that law to mean you can invoke that law only if the triple test is satisfied. So the triple test, Manoj, for the lack, prevails over any legislative exercise. Even if the state is empowered by the law to fix a percentage of reservations, the triple test is the test which they have to satisfy. If they, whether legislative or government, executive anyway they can't do it. Constitution prohibits them. So even if the so-called bill becomes law, it has to be read down to mean you can only invoke that law. The triple test is satisfied. Well, the state was Supreme Court went further and said we are setting aside all election notifications or any election results which have come also, we are setting them aside. Yes, sir. Yes. Further, we quash and set aside the impugned notifications to the extent they provide for reservation of seats for OBCs being void and non-est in law, including the follow-up actions taken on that basis. In other words, the election results of the OBC candidates which have been made subject to the outcome of these petitions, including so notified election program concerned, are declared as non-est, and the vacancy of seats caused on account of this declaration will be forthwith filled up by the State Election Commission for the remainder term of local bodies concerned. So they went a step further. They said even the elections also were declaring them as non-est. I want
Just.
I'm sorry.
Yes, yes.
My lord, in para 28, they exercise 142 power to protect those actions taken by those people. But para 29, they said, please exercise 142 power to ensure that please do not disturb the completed elections. The Supreme Court said we can't even exercise 149 power over there. Next, my lord, Lordship may kindly, now Lordship may kindly, in this triple test was applied for a series of in interim orders. Lordship may kindly see page 171. Lordship, before, I'm sorry, my lord, Lordship may kindly come to page 191. Lord, after the Maharashtra legislation was struck down, the state of Maharashtra got an ordinance, issued a law to rectify, to get over the Supreme Court order. And those actions were challenged and a series of interim orders were passed. Lordship may kindly come to 191. It's 2022-12 SCC 778. Rahul Wag was the state of Maharashtra. Para 2, my lord, at page 192. What happened, my lord, was that after the state of Maharashtra law was struck down, or read down, sorry, an ordinance was issued by the state of Maharashtra to get over overcome the Supreme Court ruling. The reason because this was an interim order passed by the court and therefore would be very helpful for this honorable court to make a determination. Page 192. The writ petition essentially assails the provisions inserted amended by Maharashtra ordinance permitting reservation for the category of other backward classes up to 27% uniformly throughout the state and the local bodies concerned. That issue has received attention of this court in Vikas Kishan Rao Gawali was the state of Maharashtra, wherein the court noted the triple test to be followed before provisioning such reservation. Para 3 lays down the triple test. Para 4 is on the Krishnamurti dictum, not para 5. To overcome the decision of this court, the impugned ordinance has been issued by the state government, and in compliance thereof, the State Election Commission, my lord, kindly notice, has already notified the election program for the local bodies concerned, which includes reservation for OBCs on the lines specified in the provisions mentioned in the impugned ordinance. The argument of Mr. So-and-so appearing for the state is that the provision inserted by the impugned ordinance is in conformity to the decision of this court. It is for providing reservation to another up to 27% only. We are not impressed with this argument. Not para 7, because they didn't appoint a commission. Then para 7, without setting up the commission and collating contemporaneous empirical data to ascertain the extent of reservation, so and so. But my emphasis on the last 4 lines. However, without waiting for its report and opinion, the state government hastened the process by issuing the ordinance, which clearly impinges upon the legal position expounded by the Constitution bench and subsequent 3-judge bench in Vikas Kishan Rao Gawali. My lord, kindly see the next para. As a result, the State Election Commission shall desist from proceeding with the election program already notified in respect of reserved seats for OBC category only in local bodies concerned. The election program in respect of local bodies across the state in respect of reserved seats for so remains state until further orders. So this was because one of the prongs of the triple test was not satisfied. Specifically with regard to percentage, 199, the next interim order, page 199. See, what happened in Maharashtra was that they did not even have that commission. The reason, page para 17, the question is whether the court should accede to the request made by the state of Maharashtra and interveners to stay the entire elections awaiting the report of the commission. In that regard, reliance has been placed on observations in Krishnamurthy, which say the reservations favor OBC, so and so, so and so. It is true that the rule of the thumb can be a proportionate reservations, but as ordained by the three-judge bench of this court, relying upon the constitutional judgment, it is imperative to abide by the triple test requirement. Now, this is important. That is the precondition to be complied with the state authorities and the State Election Commission to provide for reservation for OBCs in the local body concerned. As a result, it is not possible to countenance the argument that without complying with the triple test requirement, the state authorities or state election can be permitted to notify the seats in any of the local bodies. There is no reason to modify the order passed. I am emphasizing the same interim relief order, which was granted by the Honorable Supreme Court, that without complying with the triple test, the state is even barred from issuing a notification. This is the same interim relief I'm pressing today. One second. That's meant 183, Malak.
In this case, which of the three ingredients of the triple test you say are not fulfilled?
I'm saying 1 and 3, but for the purpose of interim relief, I'm pressing 3.
50%. That means 50%.
50%.
One, they say in the GO, and as you also say, there was some commission which made a report. That has been made the basis. But there are other facets of it also, whether it should apply across the state or even each local bodies, that which you are pointing out. This 50% cap is the one which you are insisting.
I am pressing on that, Malak. My friend may press on the other prongs, but for the purpose of interim relief, this triple test, neither executive power nor legislative power can be exercised without triple test being complied. My facts are much more easier. Today, it's only a GO.
There's no ordinance.
Today, there's a legislation in my favor. Maharashtra, there was a legislation as well.
And
they said, sorry, even if there's a legislation, you cannot exercise that power unless the triple test has been satisfied.
We'll read it down.
And they've read down that law. So even for assuming whatever that bill becomes the law and tomorrow, but today at least I have my own statute is there. I'm asked a question. Should the Secretary Panchayat Raj follow the Honorable Supreme Court order and his own Parent Act, or should he say, I'm ignoring my own Parent Act and the Supreme Court order and issue his own one?
You want to add something?
I just conclude in 2 minutes. Lordship, the last one, Madam. Lordships, the last interim order at page 183. Again, this is Madhya Pradesh, and only 2 paragraphs, my lord, at page 187.
All these interim orders are by the Supreme Court. Some of them travel straight away, some of them through High Court.
Para 13, 187. This is I can't find something any more emphatic than this one. Para 13. For until the triple test formality is completed in all respects, my lord, kindly see, in all respects, it is put in quotation marks with Honorable Supreme Court. For until the triple test formality is completed in all respects by the state government, no reservation for other backward classes can be provisioned. And if that exercise cannot be completed before the issue of election program by the State Election Commission, the seats, except reserved for scheduled castes, which so, the rest of the seats must be notified as for the general category. So today also we are not asking for the stay of the election process. We are only saying that let the elections be conducted in accordance with the law passed by the state legislature. Para 14, it was urged that population of OBC in some of the local bodies is more than 50%. And for that reason, percentage indicated in the report submitted by the commission is a conservative approach and needs to be taken forward. That cannot be the basis to disregard the constitutional mandate and need to observe the triple test procedure indicated by this court. the political parties who claim to be the protagonist of participation of OBC in the governance of local bodies are free to nominate candidates belonging to the OBC category in the constituencies concerned, and even against all the general seats available for reservation of scheduled castes and scheduled tribes. We do not wish to dilate on this on any consideration. The operative portion Madhya Pradesh came in para 27, 189. Now, just to conclude on this, page 189, only two paragraphs. 189, the same, you cannot conduct elections unless para 27. Lots of you may just make a note of that. That para 27, they say that you can't hold elections unless you comply with the triple test. And what is important, because in para 31, they say the directions we have given is not just for Maharashtra and Madhya Pradesh. It's for all states and election commissions throughout India. So, Manoj, this is critical, Manoj. Not only we now have Krishnamurthy and Vikas Gawali, but a Supreme Court order giving a direction under Article 141 that you cannot hold elections if you do not comply with the triple test. Para 31, I'm sorry. And 31. We once again make it clear that if the delimitation is not done by the state government in terms of the Amendment Act, or the triple test is completed in all respects for providing reservation so and so, the state election shall give effect to this order in respect to so and so which have become due. We also make it clear in this order that directions given are not limited to Madhya Pradesh State Election Commission, State of Madhya Pradesh, Maharashtra State Election Commission, but to all states, union territories and the respective election commission to abide by the same without fail to uphold the constitution. So the direction now given. The all states it has been given, and I'll conclude by showing Malad that the final interim order, page 171. Malad, page 174. Maharashtra went ahead and notified the elections. The Supreme Court said that since you have not complied with the triple test, you cannot proceed further. 174. When the matter came up, this is the Lordship's query. This came from the High Court. On the issue of interim, the High Court, Bombay High Court refused to grant interim relief. Matter went up to the Supreme Court. When the on the issue of interim relief only. When the matter came up before this court on 6/12/2021, it was directed that the Maharashtra State Election Commission shall not proceed with the election program as already notified, providing reservations for as a triple test compliance required under decision of 3-judge bench in this court was not done. Not the Supreme Court intervened, and then the operative directions was given for all states and page 178. The last paragraph, we reiterate that similar dispensation be followed, including the compliance of triple test by all states or union territories if they intend to conduct election of local government and provide for reservation for the OBC category. In case the state or the this is to what direction? In case the state or the union territory is not in a position to fulfill the triple test requirement and the election to any of its local bodies cannot be postponed beyond the statutory period, the concerned state election commission ought to notify the proportionate seats as open category seats and proceed with the election of the local bodies. On page 180, my lord.
These matters are pending for final
Finally,
adjudication.
but these are interim orders. So, my lord, on page 180 also, they said any election program already notified also has to comply with the triple test. My lord, so just to conclude, my lord, my submissions are number one. My submission number one, that the legislative pedigree, legislative pedigree has not been satisfied. Two, the constitutional requirement of 285A has not, sorry, the statutory requirement of 285A has not been satisfied. Three, the triple test in Krishnamurthy and Gawali has not been satisfied. And four, para 13, it must be local body specific and it cannot be done. There's a final contention, my lord, which our own High Court has said, you anyway cannot do any reservation on the basis of unpublished data. That, my friend, will show. But this is my focus. I'm grateful for your patience.
Yes, I'm appearing in item number 24 and 42, my lords. Lordship may kindly see.
You can give a small sheet, right? All these four propositions. Not in detail because detail.
One page, madam. One page.
That's similar to what my friend argued, but a little more dilation, my lords. Kindly see, my lords, my argument primarily is, my lords, there are actually two laws. The learned AG on 27th argued on legislative competence, and I seek to take issue with that. Well, when there are two laws, the law declared by the Supreme Court is law, and I would say stands on a higher pedestal than statutory law. So, my lords, there are two laws. One is the law declared by the Constitution Bench of the Honorable Supreme Court in Krishnamurthy with regard to local body election. But, my lord, they have taken inspiration from Indra Swani and have held, my lords, 15.4, 16.4. The benchmarks on which you identify persons for 15.4, 16.4 may be different, as opposed to political representation in local body election, how you identify BCs and all. Those may be different. But, and this is only relevant for your lordship, my lord, insofar as the cap of 50% is concerned, the cap of 50% will apply to 15.4, 16.4 as also the local body election articles.
This is what he has argued.
Yes. So therefore my contention, my lords, is the law says, the law as held by the Honorable Supreme Court under 142 says, under no circumstances for backward classes, you shall breach the cap of 50%. The only exception in Rakesh Kumar, my lords, which was made was that insofar as scheduled tribes are concerned, in scheduled areas,
that was
you
from
can Jharkhand. And one more point which the Honorable Supreme Court said was taking direct inspiration, my lords, in item number 42, there's a compilation. My lords may kindly see it's a yellow compilation. Just for ensuring that the page numbers match, my lords, there is an important point here, my lords, which towards the end of the argument, the state had stated before the court that there are certain exceptional circumstances in which 50% can be breached. The court has said that it is only with reference to far-flung areas which are cut off from the normal rule of life or the normal stream of life. Will you apply, can you breach 50% cap? Please see. I'll just take your lordships to that relevant portion. There's an important point here, my lords, because the state may argue that insofar as the state of Telangana is concerned, that extraordinary situation applies. That has been clarified later on. But please see, in my compilation, page 24, para 65, while dealing with the contention of senior advocate Rajiv Dhawan, please see the insert paragraphs of Indra Swani, my lords, para 65.
This is of which case? Which judgment?
This is with regard to the first case of your lordship compilation, Krishnamurthy.
Krishnamurthy.
Yes, my lord. That is that's the crucible on which all other judgments.
This was also pointed.
Yes, my lord. But this particular point I wanted to stress on, which my learned friend skipped to the next part of Rakesh Kumar. Please see para 65, the insert part of 65. Please see this. from the above discussion, my lords are there, my lord. This is directly applying the principle in Indra Swani. From the above discussion, the irresistible conclusion is that follows is the reservations contemplated in clause 4 of Article 16 should not exceed 50%. Now, while 50% shall be the rule, it is necessary not to put out of consideration certain extraordinary situations inherent in the great diversity of this country and the people. It might happen that in far-flung and remote areas, the population, Lordship may stress on those words, madam, population inhabiting those areas might, on account of their being out of the mainstream of national life and in view of conditions peculiar to and characteristical to them, need to be treated in a different way. Some relaxation in the strict rule may become imperative. In doing so, extreme caution is to be exercised and a special case made out. Now, my friend read out the fact that this exception has been applied to northeastern states, far-flung areas where almost 100% are reservations in excess of 50% do exist in some exceptional cases when it comes to the domain of political representation. For instance, legislative assemblies of the state of Arunachal Pradesh, Nagaland, Meghalaya, Mizoram, Sikkim. Recent decision as in Union of India, this court explained that why it may be necessary to provide reservations in favor of scheduled tribes that exceed 50% of the seats in panchayat located in scheduled areas. Therefore, the exception has been made only for scheduled castes and scheduled tribes. But in so far as backward classes are concerned, however, such exceptional considerations cannot be invoked when we are examining the quantum of reservation in favor of backward classes for the purpose of local bodies located in general areas. So we are talking of general areas, my lords. Your lordships had asked a question whether we are talking of a district. It is not a district. It is general area, the entire state of Telangana which we are discussing, my lord. On this point, I would make a respectful submission with the greatest respect to this honorable bench. This honorable bench is bound by a by a full bench order of this honorable court way back in 87, when the state wanted to increase the reservation to 44%. In your lordship's compilation, please see this decision, my lord. Your lordships, my lords, with greatest respect, my lord, the court, this honorable court is bound by that decision. I'll only take your lordships to the operative portion of this lordship's decision, just Jeevan Reddy's decision, my lord. Please see page 568. The decision begins, my lords, at 553. 553. It has become final. They struck down the reservation for BCs, which was made to 44%. Now, my lords, it was with regard to 15.4 and 16.4. Please see, I'm sorry, my lords, for the bulkness of this compilation. Page 568. The decision begins. Yes, my lord. V. Narayan Rao and another versus the state of it. Yes, please give a copy. Please see that copy. Now the decision begins. My lords, please see at page 553. Yes. Please see, the operative portion which your lordship will see at 568 for a moment. This is a 3-judge bench. It has become final. 44% reservation has been introduced, and the court strikes down that 44% reservation. Now, my lords, before your lordships read this, recently in 2018, the state sought to increase the reservation to 34%. That by interim relief, the court stayed it, applying the principle of Krishnamurti. This was even before 285 Cap A came on the statute book. But please see page 568. Now, this is before, my lords, the jurisprudence of Indra Swani came about. My lords, incidentally, the same learned judge gave that decision. But yes, my lord. Yes, 123, page 568. In fact, this decision has been referred to in Indra Swani also and referred to in Maratha Reservation, but please see this one. The above discussion yields the following broad propositions. The rule enunciated in Balaji and affirmed in Devdasan is that reservation of seats posts cannot exceed 50%. Now, this is before jurisprudence of Indra Swani comes about, based upon the Honorable Supreme Court Constitution Bench decision in Balaji. Maybe it is a ceiling, maybe it is only a rule of caution, but it has got to be adhered to. Lordship may stress this. Later on, the carry forward rule has been discussed. The Lords may not see that kindly, but please see para 124. In the light of the above principles, we must hold that the raising of the quota of reservation for backward classes to 44%, which together with unquestioned reservation, please notice this word 44, it's now 42, but it was done 44 then, which together with unquestioned reservation in favor of scheduled castes and scheduled tribes comes to 65%. Now it is 67, 2% more, then it was 65%. Is far in excess of the permissible level of reservation and must accordingly be held to be bad. The state may argue, my lord, this decision is with regard to 15.4 and 16.4. We hasten to submit that in Krishnamurti they said the cap of 50% as applied in 15.4, 16.4 by Indra Swani applies on all forced local reservation. So the principle which has been laid down in this decision applies completely to this. And please notice that the operative portion of the order, my lord, in view, now please notice page 570, clause 6, my lord. In view of the decisions of the Supreme Court, my lords are there, I'm just reading point 6, my lord. Page 570. In view of the decisions of the Supreme Court referred to in our judgment, the total reservations under 15.4, 16.4, as the case may be, cannot as a general rule. The court had to say general rule because the rule had not yet been solidified, which it happens later on in Indra Swani 9-judge bench and so on. So they are saying as a general rule, exceed 50%, subject to marginal adjustment if the exigency so require. Situation may, however, be different whether carry forward rule is applied. The exigencies your lordships have seen, the Honorable Supreme Court explained that far-flung principle. Therefore, my lords, they strike down at page 572, clause 13, 14, 15 of GOMS 166. My lords, please see para 126, clause 13, 14, 15 and 18 of GOMS 166 dated 15/7/86 are struck down as violative of 15 and 16 of the Constitution. So the GOMS, which provides for 44% reservation, which takes the reservation to 65%, are struck down by this court. I put a simple question to myself: if the full bench of this honorable court has held that the 65% reservation is bad because it violates 50% reservation, well, the question before this honorable court is, this court may, with great respect, be bound by this decision. There's another 3-judge bench decision, my lords, of the Honorable High Court, my lords, wherein the second part of my learned friend's enunciation of that three-test principle, my lords, the triple test, you must have a commission. The commission must conduct a study, an empirical study. How that study is to be conducted was envisaged in this, and again a 3-judge bench decision, my lord. Please see this judgment given by the same learned judge, my lord. Please see page 458 and 459.
Need not multiply the authority.
Yes, but I'm only trying to submit, my lord, that when a report is there and they're relying on the report in the GO, the report has to be published, objections have to be invited, and there has to be a process of that. If you don't do that, the report is bad in law is our submission. So my learned friend was referring to 1 and 3, 50% and the appointment of the commission. I'm referring to the manner of the manner in which the commission conducted its exercise. I'll just read this one point, Malad, if you're not able to see, page 458. If, however, this is again a 3-judge bench. Please see 458, the same learned judge, Malad. Page 458. It's the opinion is by 2 learned judges, Malad. I'm only reading one learned judge's opinion. They are all concurring opinions. Page 458. 458, para 25, the last sentence, if however, my lords are there, Malad, from the bottom, if however, page 458.
Yes,
yes, para 35, yes. Malad. If however, from the bottom, my lords, please notice this. If however, this survey is sought to be made the basis for any other election, hereinafter, it shall not be so used unless it is published first, objections invited, considered, and after necessary inquiry. We are all innocent of this report. The state, my lords, refers to the report as the basis of the GO and says an empirical study was done by one-man commission. Where is this report? Have objections been invited? Has it been published? Completely silent.
Yes.
And please notice this, Malad. I should also not be understood in either affirming the truth of the said figures or the validity of the said survey. So in effect, what the court is saying, my lords, is that we shall not rely on a survey which has been done behind the back of the people.
Understood.
My lord, this is what, so my lord, there are 3 judge, both are 3-judge bench opinions, my lord. Both with greatest respect are binding on this honorable court. And if your lordship were to see section, now this is the law on the point. I just want to emphasize one point, my lords. My learned implete respondents, my lord, are saying, my lord, that the interests of backward classes are not being protected if this is not done. The chairman of the Constituent Assembly, my lords, Dr. Ambedkar, in Maratha reservation case, himself has said, and the basis for this 50% rule is not an invention of the court. But, my lord, the basis of that, the germ of it was in the Constituent Assembly. I'll just refer to that one paragraph of Dr. Ambedkar, my lord, wherein he said to maintain a parity between formal equality in 15.1 and substantive equality in 15.4. A minority of the seats must only be reserved. You can't have it as a majority. He said if you reserve it for the majority, you will be denuding 15.1 and 16.1 of its content. And that will be violative of the constitution. I'll just refer to that one paragraph because, my lords, what I was curious to know, is this an invention of the court? Is this a jurisprudence of the court? Or has its germs already been laid in the Constituent Assembly? Lordship may only see this one paragraph, my lords. Page 329 of the Maratha reservation case by Honorable Justice Ashok Bhushan, my lords. It's a final order. It has some review apparently has been filed. They examined in great detail when the petitioners argued, the state of Maharashtra argued that this 50% rule is a yardstick of the court. It needs to be reviewed. Please see page 329, para 391. Yes, madam. Dr. Ambedkar referred to Article 10.1 as a generic principle. Dr. Ambedkar observed that if the reservation is to be consistent on clause 1 of Article 10, well, these later came to be Article 15. It must confine to the reservation of minority of seats. And the Lordship's quote the Constituent Assembly debate of that learned scholar, my lords, please see. The following is the part of the speech of Dr. Ambedkar in the Constituent Assembly. Now this is the actual speech. If honorable members will bear these facts in mind, the 3 principles we have to reconcile, they will see that no better formula could be produced than the one that is embodied in clause 3 of Article 10 of the Constitution, they will find that the view of those who believe and hold that there shall be equality of opportunities has been embodied in clause 1 of Article 10. It is a generic principle. At the same time, as I said, we had to reconcile this formula with the demand made by certain communities that the administration, which has now for historical reasons been controlled by one community or a few community, that situation should disappear, and the others also must have an opportunity of getting into public services. So he's looking at both the competing claims. One claim which says that reservation should be there, and the other one which says that reservation should not be there. Please see how he reconciles these conflicting views, Mala. Supposing, for instance, we are to consider. Yes, I'll just finish,
So
Mala.
we saw that.
Yeah. I'll just finish, Mala, if my lords were so, bear with me. Supposing, for instance, we are to concede in full the demand of those communities who have not been so far employed in public services to the fullest extent, what would really happen is we shall be completely destroying the first proposition upon which we are all agreed, namely that there shall be equality of opportunity. So if you give reservation in the manner in which the state is proposing to do now, 67% is vertical, my lords. You also have horizontal reservation which will cut through vertical reservation for women. So you have reservation for women which will cut through the general reservation and also will cut through the vertical reservation. This will be almost completely giving reservations, and which, my lords, the chairman is envisaging should not be done because it violates equality of opportunity under 16(1). Let me give an illustration. Supposing, for instance, reservation were made for a community or a collection of community, the total of which came to something like 70%. We are now talking of 67%. Constituent Assembly in 47-48 is looking at 70% reservation. Please see what he says on this. Of the total posts under the state, and only 30% are retained to the unreserved. Could anybody say that reservation of 30% as open to general competition would be satisfactory from the point of view of giving effect to the first principle, namely that there shall be equality of opportunity? So he's looking at the condition. If you give 70% reservation and you only leave out 30% to the general part, will you be giving enough credence to equality of opportunity? And there's his answer now, madam. It cannot be in my judgment. Therefore, the seats to be reserved, if the reservation is to be consistent with clause 1 of Article 10, must be confined to a minority of the seats. So this is the intention of the Constituent Assembly. My lords, always, when your lordships are interpreting constitutional or statutory provisions, are free to look at secondary modes of interpretation, one of which is the Constituent Assembly debates. Whereas if we go back and examine why your lordships put that benchmark of 50%, my submission is it is there in the Constituent Assembly debates. This, understood. Yes, my lord. I'll just summarize. My lord, therefore, my lord, my respectful submission is this is what the law says. Now, if your lordship were to come to the statute, just for a moment, I'll read the statute. And it is, my respectful submission is, the statute, it's not a substantive provision. All that the statute did in 2018 December was to give effect. The intention was to give effect to what the Honorable Supreme Court has been saying. So please notice this. Supreme Court is saying, in pursuance of the judgment, I can't think of a section which begins like this. In pursuance of the judgments of the Honor, in fact, Justice Shavali said they should have referred to the judgments of the Supreme Court, then the section would have been complete. He said so in the arguments on 27th, but your lordships have now seen the decisions. In pursuance of the judgment of the Supreme Court of India, the upper ceiling of 50% vertical reservation should not be breached. And accordingly, this is the first part. The second part, the state has not complied with. Please see the second part also. And notwithstanding anything contained in 917 so and so and elsewhere in the Act, providing reservation for scheduled caste, scheduled tribes, the seats and offices to be reserved for backward classes shall be so determined, duly keeping, only one submission, duly keeping in view the requirement of reservation for SCs, STs therein. So what the section is saying is, no doubt, You may make reservation for BCs, but while you're doing so, you must also keep the interests of SCs and STs in your mind. The state has not done that. Why they did not do that is, they have taken 2011 census of SCs and STs. Your lordship will see that in item number 24, my lords, or item number 42, in the Panchayat Raj Geo 41, which has also been challenged before your lordship, it is really eye-opening. Because what they're doing is violating the section, my lords. Please see. Page 32. The Panchayat Raj Geo, my lords, gives out the census for SCs, STs and BCs also. Please notice this table only for a moment, my lords. Page 32. So what the section is saying is, while you are making reservations for BCs, keep the interests of SCs, STs in mind. The Geo says there has been a proportionate increase of BCs. Therefore, we are reserving for BCs. The section says, no, you should keep the interests of SCs and STs also in mind. If that is so, what has the state done? Please see page 32 for a moment. At page 32,
Geo 41.
Page, Geo 41, my lords. In item 42, my lords are seeing. Yes, my lord. Please see the second page of Geo 41, my lords. 41. The table, it's eye-opening because in so far as ST, SC population are concerned, they take the 2011 census. But in so far as BC populations are concerned, they are taking this the survey which has been done in 2024. Why? Well, if the section has to be given full effect too, which they are bound to do, shouldn't they have looked at the SC, ST population by undertaking the same examination for BCs, which they have taken up in 24? They should then come to a conclusion that the proportionate increase of SC, STs are not as much as BCs, and therefore we are making provision only for BCs. Argument's sake, if they do this exercise, they come to know that SC, ST population is very low. BC population has increased. They are not being properly represented in public life. We are giving effect to them. Have they done that? They have not done that. They have only looked at the population figures of BCs in 2024 as opposed to ST, STs in 2011. This violates the act, my lords. And one more submission is that it violates the act. The state was saying on the last occasion, on 27th, my lord, they said that Justice Pardiwala's opinion in State of Tamil Nadu decision has said if it is kept for the assent of the governor for a period of 1 month, it constitutes consent. I'll just put a question to myself. With great respect to the state, that is not what the Honorable Supreme Court has said in state judgment. Well, please take this copy. Well, this is important because on 31st of August, I'm sorry we are taking your lordships to this voluminous documents, but lordship will notice the State of Tamil Nadu versus Governor of Tamil Nadu. The direction insofar as the president is concerned has been given back by the president to the Supreme Court under advisory jurisdiction of can you do that. But please notice, para 250.
Yes.
Please see page 2, para 250. At page 212, the bottom portion has the page numberings. What I'm only trying to say is that the Geo has only recorded the fact that it is a bill. Unless it receives the governor's assent, it is not an amended situation. What the Supreme Court is saying, it's not like a deemed approval, my lords. Please see. Keeping in mind my lords are saying para 250. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Failure to comply with these timelines would make the inaction of the governor subject to review, not deemed approval, subject to review by the courts. In case of either withholding of assent or reservation of the bill for the consideration of the president, upon the aid and advice of the State Council of Ministers, the governor is expected, please notice that word, it's not a direction, It is an expectation. My lords, they have stretched 142 article to its limits. And 142 article has been, so they're very careful as to how they are referring to their equals in the executive side, which is the governor or the president. The governor is expected to take such an action forthwith, subject to a maximum period of 1 month. He has to take action. Now see what happens. In case of withholding of assent, contrary to the advice of the State Council of Ministers, the governor must return the bill together with a message within a maximum period of 3 months. So he has to take action forthwith within a period of 1 month. If he disagrees, he must give back the bill within a period of 3 months. These timelines are important if we are to take this assumed consent or whatever. In case of reservation of bills for the consideration of the president, contrary to the advice of the State Council, the governor shall make such reservation within a maximum period of 3 months. So you should decide within 1 month. If you don't decide within 3 months, you must give it back to the Council of Ministers. And then, my lords, in case of presentation of bill after reconsideration, in accordance with the first proviso, the governor must grant assent. Now, please notice that word grant assent forthwith, subject to a maximum period of 1 month. But you can't read this sentence in isolation, independent of the earlier provisions, my lords, or earlier direction. So what it says is, you decide in 1 month. If you don't decide, give it back in the next 3 months. And if it comes back to you for after reconsideration of your council, if it comes back to you, then within 1 month, if you don't decide, then it is assumed assent. That exercise has not taken place at all. As my learned friend has submitted, on 31st of August, the legislature has passed a bill. They have kept it for the assent of the governor. We are still in the first August, September. 1 month has passed by. Now the second part of this provision, that within 3 months you must give it back to your Council of Ministers, that has come into effect now. After that is over, they give back the bill back to you. Then you must decide within a period of 1 month. If you don't, then there is assumed consent. But what the state appears to be arguing is, because in 1 month you didn't decide, therefore there is assumed consent. Well, that is also an argument in futility. Because the law declared by your lordships in the Honorable Supreme Court has said 50% cannot be breached.
All that.
Also, please also notice, my lords, just to conclude, my lords, in item 42, in item 202, item 42. In item 42, just one last submission, my lords, I'll just bet. In 2018, 34% reservation was introduced by the state. This came to be challenged before your lordships. In an interim order, your lordships stayed it. They said
was shown. That
yes.
was shown.
That was not shown, my lords. Please see page 202. Only for a moment, please see page 202. I'll conclude, my lords, with great respect. I think I've gone into your lordship's lunch hour.
So great reservation is required for my lords.
Just see in item 42, just one paragraph I'll show. If your lordship were to see in item 40,
please read it.
Shall I read it? Yes, madam. This is in page 202. Is item number 42, my lords. Page 202. This is my lords, WP 25651 of 18. The fundamental issue, and this may be revelatory, my lords, when your lordships are considering whether to give or not to give interim relief. This interim order has been given 6 months before the enactment of 285 Cap A. It was given in the month of July. 285 Cap A came into the statute book in December of 18. The interim order is given in July of 18. So they're relying only on Supreme Court decisions without going into the thicket of section 285 Cap A. Well, please see, the fundamental issue, that's why I wanted your lordships to kindly see it, my lord. The fundamental issue raised in this writ petition is regarding the reservation of seats in Gram Panchayats and other local bodies, which we hereinafter refer to as local self-government. The fundamental contention of the petitioner is that the reservation is in excess of 50%, which could not have been made in the light of the Constitution bench decision. Only one decision the petitioner relies on, Krishnamurthy, and says 50% breach violates Krishnamurthy, please interfere. That's all he says. That's all the court also says now. Please see. In the light of Constitution bench decision of the Apex Court in K. Krishnamurthy versus Union of India, the learned counsel for the petitioner making reference to the said precedent argued the position that it amounts to law by the Apex Court. Now, please notice the operative portion, my lord, and this is revelatory. I'll just read that one paragraph and leave it, my lord. However, of the view that the law laid down by the Apex Court is clear and categorical to the effect that the upper ceiling of 50% vertical reservation in favor of SC, ST, OBCs should not be breached in the interest of scheduled tribes should not be breached in the context of local self-government. Exception can only be made to safeguard the interest of scheduled tribes that your lordships have seen. In the matter of the representation in panchayats located in the scheduled areas, this is one of the specific enumeration conclusions rendered by the Constitution bench after stating to the said effect in paragraph 64. So your lordships are referring to a paragraph and giving an interim order. This was before the act came into being. Paragraph 64 of page 227 of the judgment in K. Krishnamurthy, wherein the Apex Court had clearly taken the view that there cannot be any vertical reservation in excess of what has been noted above, that is over 50%. It has also to be noted that K. Krishnamurthy was decided making specific reference to the Constitution so-and-so amendment. Considering the submission of the learned GP on the basis of, this is the same thing they argued. The OBC population of the state has increased, we need to give them more reservation. My lords, OBC population, we are of the view that the only exception granted by the Apex Court through the directions in K. Krishnamurthy is only as regards STs and SCs. So the court is saying the only allowance which we can make to the state is with regard to SCs and STs when it goes above 50%, not to OBCs. Therefore, we do not find our way to accept the submission of the learned G. For the aforesaid reason, there shall be interim order that the upper ceiling limit of vertical reservation in favor of SC, STs and OBCs should not be breached in the context of local self-government in the state of Telangana, subject of course to the exception that safeguards could be made to protect the interests of scheduled tribes in the matter of representation in panchayat located in scheduled areas. So this interlocutory order is issued without prejudice. Against this order, the state goes in appeal to the Honorable Supreme Court, and then the SLP is withdrawn at page 205.
Very well.
So all I'm submitting, my lords, it's still the law of the land.
Hear the other side after lunch.
No,
My
I
lord,
wish
may
to.
I please, my lord? My lord, this is with reference to this matter. My lord, leave me a moment.
We have heard this at the interim stage only. We'll hear the other side.
I wish to add for 10 minutes, 5 minutes, I'll take up. I'll be supporting this.
My lord,
And I'll not repeat what they have said.
Allow us to have the lunch.
I'm sorry. I'm sorry again.
and grade wise at appropriate percentages. Then, Malads, please see para 169. This is a convenient judgment because it quotes the relevant parts of all the other judgments. Para 169.
Yes, yes.
In Jayashree Patil, Justice Bhatt, after analyzing Indira Sahni, said, a careful reading of the judgments in Indira Sahni clarifies that 7 out of 9 judges concurred that there exists a quantitative limit on reservation, spelled out at 50%. In the opinion of 4 judges, as per Justice Jeevan Reddy's estimate, this limit could be exceeded under extraordinary circumstances and in conditions for which separate justification has to be forthcoming by the state. However, that there is unanimity in the conclusion of all 7 that an outer limit for reservation should be 50%. Undoubtedly, the other 2 judges, Justice Pandyan and Sawant, indicate there is no general rule of 50% on reservation. In these circumstances, given the general common agreement about the existence of an outer limit, the particular argument about the incoherence or uncertainty about the existence of the rule, or that there were contrary observations with respect to absence of any feeling in Tevadas and etc., or these other judgments of the next page, brothers, is not an argument compelling a review or reconsideration of Indira Sahni.
Yes.
Then, brothers, 170, they say it has received constitutional significance, the 50% rule. Then come to 171. So they are at the moment quoting various judgments, including Justice Bhushan, Justice Bhatt. Thus, having examined the permissible limits of affirmative action in light of the possible harm of preferential treatment, this court has expressed the desirability of 50% as the ceiling for reservation in education and employment. But as observed herein above, all such observations are required to be read essentially in the context of reservation obtaining under 4, 5 and 4. That is 15.4, 15.5 and 16.4. Or other areas of affirmative action like that in relation to local self-government. They cannot be overstretched to the reservation provided for entirely different class consisting of economically weaker sections. Because this judgment barred it, therefore, the constitutional amendment was passed for EWS. Because that time, there was never a doubt about BC reservation. The dispute was about EWS. I hope I am clear. You could exceed 50% for BCs, but EWS was a new category. Then come to 172. So that is why this para was meant to as a bar for the EWS, which is why the constitutional amendment came. Then, moreover, as noticed, this ceiling limit, though held attached to the constitutional amendment, has not been held to be inflexible and inviolable for all times to come. That's extremely important. My lord has got that.
Yes.
Reasons for this are not far to seek. As mentioned here and above, reservation by affirmative action is not having trappings of any such essential feature of the Constitution, as in Malas Keshwanand, and successive decision, that is modulation with reference to any particular compelling reason, could damage the basic structure. Now, Malas, what are they saying here? That this 50% can be flexible. You need not. Can I seek, Malas, 1 minute of your lordship's time? Just 1 minute, if your lordship doesn't mind.
Yes, yes.
Gone back to 600 pages. State is fact.
There is no legislation. उसका आंसर ये दिए हुए हैं इसमें पर Secondly, Gaudi are you local body of third one of 50% cap. Three governments have added a voting system with everywhere 1660 and the requirement to उसमें उनका क्या बोलेंगे इसी तरीके मान लीजिए तो नोटिफिकेशन वगैरह क्यों नहीं निकालते डीम्ड वाला जो है अल्टीमेटली नोटिफाइड होगा ना enacted in such and such date extraordinary gazette published in such and such. लेकिन ये नहीं है बस उसके बदले में एक ऑर्डिनेंस निकाला है ऑर्डिनेंस गवर्नर ने साइन कर दिया उसको भी तो अपनी जुलाई में वही चीज़ का एक ऑर्डिनेंस निकाला इंप्लीमेंटाइज हो गया गवर्नर सर्विस की बात ऑर्डिनेंस निकाला ये दोनों का जो भी लॉ पास हुआ है जस्ट इसको तो नहीं
My apologies, Vince. My apologies. So 172 is very important for the point that please don't think that the 50% rule is part of basic structure. It is not inviolable as basic structure, is what they are saying and ending on that. Well, therefore, so long as you have data, the law provides no prohibition. You are also at the interim stage. There is no straight per se infirmity of 2 plus 2 is equal to 5, which necessitates the stay. Now, the third and last point, two more points, the penultimate point, is this complete misunderstanding about the nature of the act passed under the new regime of the Supreme Court. The Supreme Court and I had the privilege of assisting the court in diverse cases arising prior to Tamil Nadu from West Bengal, before that from Punjab, the very important judgment of Punjab, then Tamil Nadu, then West Bengal, then Tamil Nadu. In all these cases, there was a paradigm which had developed. Good, bad or indifferent, something never contemplated by Dr. Ambedkar or the entire Constituent Assembly, because everything is not written. Everything is not written in the Constitution. It depends on the spirit and good governance notions to run it. Across India, in state after state, where especially the political color of the state dispensation was different from the political color at the center. In some states, especially the three named now, which I just named, governors would sit on bills and neither return, nor assent, nor refer to President. Now, Article 200 has three very clear options, extremely clear. And the constituent framers never imagined that you will find a fourth one, like a Trishanku of suspended animation, of not doing any of the three. So, that led to a situation where in Tamil Nadu, for 5 years, bills were kept pending. In Bengal, for years and months, it was kept pending, and the matter landed up in a Tamil Nadu petition before the Supreme Court. In that, the Supreme Court has given clear directions. There is no question of suggestive, no question of advisory, as was argued in the morning. And no argument is open that, look, we will consider the stretching of the limits of 141, 142, therefore, Lordship may ignore it. Now, let us see 3 paras of that judgment in the light of this one. Just note 2 dates before Lordship comes to that judgment. The legislation is passed on 17/3/25. Please make a note of this.
Yes.
And the governor sending is on 5 days later, on 22nd of March 25. These are admitted dates.
Yes.
Now, your Lordship knows, there's a very famous saying in the Constituent Assembly, no two swords in one scabbard. Ek म्यान में दो तलवार नहीं. The Chief Minister is the elected representative of the state. I always like to submit that an elected representative has the elected right, to do good, but equally to do not so right and maybe wrong. That's his good luck or bad luck. It's his vivek. That does not mean that your lordship has a separate power in a governor to act as a super chief minister. There are no two swords in a scabbard. Your lordship will be surprised. We have all this is reproduced. We had argued it for Tamil Nadu Justice Padiwala to reproduce it. Whereas there were passages saying that Dr. Ambedkar said that we want to have a nomination. Sorry, we want to have an election of a governor. Not he, a lot of other people. He opposed it, saying that we are making it such an ornamental post. He used the word ornamental, not my word. That we are worried that nobody may want to become a governor. Then finally they settled for nomination. And then in the discussion they said this whole thing is done so that there is no power in the governor to second guess a chief minister. And 200, if your lordship picks up and reads for 30 seconds with me, is a clear tripartite distinction, and then I read the judgment. You must return, you must assent, or you may refer. Lordship, just pick up the Constitution for 30 seconds, please. Article 200. So please understand the context in which a helpless Supreme Court at the end of its tether with multiple judgments. This was preceded by Banwari Lal, a Supreme Court judgment authored by Chief Justice Chandrachud in Denver on the same line. But the actual time limit, because there's no point giving long sermons and not having teeth or not having a remedy. No point giving rights without a remedy.
27 days, including those 2 days.
Yes.
There is somebody who's competing with me on the mic. Anyway, 200. When a bill may I read, Manas? When a bill has been passed by the Legislative Assembly of the state, or in the case of a state having a legislative council, has been passed by both houses, it shall be presented to the governor. Now note this, Manas. 3 options only. And the governor shall declare either that he assents or that he withholds. Now withhold is covered in the proviso. Or that he sends it to reserves the bill for the considered president. Only 3. The second one they elaborate by saying that if you send it back and the legislature sends it back, then he is bound. Now here the error of the argument of one of the learned counsel in the morning is to omit the fact that the governor has never sent it back. I hope I am clear about it. The governor has never sent the 7th March bill back. 17th March bill sent on 22nd March back. The question of the legislature sending it back will not arise. Therefore, now the paras of Justice Padiwala's judgment kick into action straight away. Please hand over the compilation, page 1831 it starts, volume 3, volume 4. And the whole purpose of this law was that you cannot paralyze state administration because you are second guessing the governor and the council of ministers. They have the right to do right, they have the right to do wrong. The electorate will deal with it or judicial review will strike it down. The governor can't withhold endlessly without declaring, without sending back, without sending anywhere else and sit on it. Squatting is not an option. Squatting on a bill sent to you is not an option. If you squat, then 1 month later, the bill is deemed to be passed. In this volume, it starts at 1831.
1831.
I will read 3 paras and the conclusion. May I read, Manas?
Yes, yes.
It's a long, detailed judgment. The bench labored hard and wide and across the globe. All precedents, entire Constituent Assembly debates. It's a very, very well written and a very comprehensive judgment after considering everything. And we argued it, Manas, over a period with the Monday-Friday interruptions of over 2 months. Now let us come to 3 paras in sequence, only 3, and 1 conclusion, 4 paras. First is para 240.
Yes.
That is at page 2037.
Yes, yes.
Thus, it is important to take note of this very fine but pertinent distinction that the prescription of a time limit by this court into 200 of the Constitution does not fundamentally change the procedure which has been envisaged. While the reading in of a time limit under 200 would have meant that there would be deemed assent upon failure of the governor to comply with the said timeline. The prescription of a reasonable time period does not introduce any such mechanism or deeming fiction in Article 200. Well, I would beseech my lord that you study. I'm not reading in detail. Lordships can certainly read in detail. I'm only reading 3 paras, but it's something which really requires study. And I'm not doing justice to it by not reading it in detail. Then, Wallace, they say that this is not creating a new mechanism which is beyond the Constitution. It is fulfilling the Constitution. And they then do it actually in para 250 at page 2043. 250.
Yes,
the actual
yes.
timelines. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Prescribed, not optional, not suggestive, not recommendatory, mandatory. Failure to comply with this timeline will make the inaction subject to judicial review. In case of either withholding or assent or reservation for the consideration upon the aided advice, the governor is expected to take such an action forthwith, subject to a maximum period of 1 month. That is the category for us. The return of the bill has not happened. That is the second category of 3 months. Wrongly told to your lordships. That is para double I. There is no return of the bill. I'll tell you why also we discussed this in practical terms when we argued the matter. Governors choose sometimes not to send it back because if I send it back and the legislature sends it back to the next day, then you are bound.
We have 2 questions. I've heard you quite length of, in fact, 3.
Well, it's just 5 minutes more and I'm done. 5 minutes more.
Very well, very well. You can.
This judgment ends at page, the relevant part of this point ends at para 435, just above 436 at page 2240. That is para 435 bracket C at page 2240.
Yes.
And this is not the first case. It followed upon Punjab. Where I had the privilege of assisting the court in Punjab, and this Punjab is followed here and applied here. Having regard to the unduly long period for the time in which bills have been kept pending by the governor before the ultimate declaration of withholding of assent, in view of the scant respect showed by the governor to the decision of this court in state of Punjab, and other extraneous considerations that appear to be writ large in the discharge, we are left with no other option but to exercise our inherent powers under 142 for the purpose of declaring these 10 bills as deemed to have been assented on the date they were presented after being reconsidered by the legislature on 1811. That's the operative part. And the conclusions are subpara 9, small Roman 9, at page 2222. There is 2222. There's a long list of conclusions, if your lordship notes, it starts at 2218. 2218. If my lord will just turn to 2218 and note the first one. The 3 options are given. Only 3, no 4th option of just squatting. There is no 4th option of squatting. There are only 3 options at page 2218, para 434, small Roman 1. Assent, withhold assent, or reserve. There is no 4th option. Then, your lordship sees small Roman 9 at 2222. This is the law of the land now. The bills having been pending with the governor for an unduly long period, the governor acting in clear lack of bona fide and reserving for consideration immediately after pronouncement, are deemed to have been assented to on the date they were presented to him after being reconsidered. Then, as I end, just one point, I'll be very sorry, I'll just await your lordship's query after that. There is a general principle that your lordship, even if the act was challenged directly, does not stay the operation of an act, except in exceptional circumstances. Your lordship is aware of the principle, cases have held it repeatedly. Here, without the act being challenged, the inexorable consequence of the act, the GO, is sought to be stayed on the last day of the before coming into force, and your lordship should not even say subject to outcome, is the case of the petitioner. There is no operational fetter or stay on the judgments of the Supreme Court in Punjab and Tamil Nadu. The misleading impression given by certain advisory opinions which have been referred, there has been no stay and there is not an appeal. There is no intra-court appeal in the Supreme Court. The Supreme Court is final. It is right because it is final. It is not final because it is right. Ultimately, you may go in reviews and curatives, but it is right because it is final, and there is a finality attached to it. Well, those are my submissions. I would at the end beseech my lords to not nullify such a detailed, well thought out, intensive, analytical, bona fide exercise in the prerogative of the elected members across the political spectrum, all of whom believe that this is good for a state. By an interim order before completion of pleadings without final hearing at this stage, and most of this can be achieved by making it explicitly subject to the outcome. I'm done, Manoj. I'm very sorry I interrupted your lordship. Lordship will put those questions to me.
There were out of number of points that were urged on behalf of the petitioners.
Yes.
I would pose the 3 points which we feel you need an answer to.
Yes.
As it appears from the chronology of your dates.
Yes.
After the bill was sent to the governor, and the period as per the Tamil Nadu judgment was over.
Yes.
If the government in power felt that it is a deemed consent, was it notified? Probably not.
No, but the whole purpose of deemed consent as we understood it.
No, so therefore,
yes,
what we understand that therefore in July an ordinance was passed.
Yes, yes.
So this government was also not under an impression that it was a deemed consent and therefore the necessity of a ordinance. Now ordinance is as good as law with its little time limit which it has for its life.
Yes.
So this is the first issue, that if the government thought about a deemed consent, it has not notified, but instead
may I just clarify, Manoj? The bill which was sent for the governors and which we say is deemed assent is the 17th March 25 bill number 9.
Right.
In my legislature. The ordinance is to the cognate parallel act regarding the Panchayati Consequential Act. That is the Consequential Act. I am putting this reservation into panchayats. Tomorrow I will put it into education. Day after into public service employment.
So then that
the amendment is the consequential thing where I want to place the reservations.
So then the 17th March bill which was passed was not notified as yet.
Whereas the bill is once it is deemed assent act, it is self-operative from the act.
No, for the people to come to know that it is an act, there is a further act of notifying it in an extraordinary gazette to be made effective from a particular date.
Well, that the learned AG, I am told, has that document, whereas I don't have it. It was recognized and acted upon and known to the public.
Subject to
that is one.
Clarification.
But your lordship may clarify that this ordinance is about the Panchayati consequential, not about this one.
Do you? We have not seen that July 2025 ordinance.
Yes.
But the 2 bills relating to amendments to the Panchayat Act and the Municipalities Act, which were passed in late August 2025 and have been sent to the governor, they are also awaiting assent. But
yes. But the ordinance is on the record of this volume, page 121. Which I
very well. So does
volume 2.
The ordinance is for amendment to the Panchayat Act or Municipalities Act or both?
Panchayat Act.
Okay. So
that is the 2018 Act.
So the relevant provisions which were finally passed by the Legislative Assembly in late August, they were already promulgated by way of an ordinance in July 2025.
Correct.
Is that
correct?
Very well. Secondly, judgments all of both sides have referred to. In matters of reservation to these local bodies, there is a judgment of three-judge bench in Gauli's case, where the again triple test has been reiterated.
I'm very grateful. I'm very grateful. The answer is there clearly, and we satisfied.
No,
Please turn to Gauli.
Let me first
articulate
the full question.
My apologies.
So, all the judgments in Indrasani or the later judgment which you referred to, they propose a general exception in exceptional circumstances that the sealing is not sacrosanct.
Obliged.
But the Gauli's case, in a case of a local body itself, says 50% is sacrosanct. Now, how does the state or any state for that matter get over it? All these ceiling limits which are being crossed by different states, they ultimately are being challenged and are being taken up.
I appreciate.
So this Gauli judgment.
May I answer, Balas?
And third, so that you may also think over the third issue, the local areas in which all these panchayats are there, they may have different proportion or demography or levels of representation or presence of backward classes. But this GO 9 uniformly applies that 42% across the state. Whereas if the empirical exercise is done like it was done, say, in some other state, then it could have been tailor-made to the requirement of different panchayat bodies in different districts for that matter, instead of a wholesale uniform 42%. There, whether sufficient application of mind has gone into that or not by the commission or by the body collecting the data and the government which has accepted it.
Yes, please. May I answer, please?
Fourth question.
May I answer, please? Just 2 minutes.
There is one more question which my brother rightly.
Yes.
That after this data, etc., are published and the commission submits a report, is there not a requirement for publication and inviting objection and then dealing with the objection and accepting it?
Right, I appreciate it. May I answer, Willis?
Yes.
So let me answer, Willis. First of all, let me take the last point. Yes. This is a exercise for a government to make a policy decision, then on that policy decision to pass an act of parliament of a state legislature, and then to implement it. It is not an exercise where it's a legislative exercise which translates an in-house exercise of collecting data into legislation to educate and inform yourself. There is no procedure under any statute or under any common law that an exercise to collect data for the demographic profile of your own state itself requires natural justice or hearing or inviting objections to decide the validity of the data you collected. That is one of the first answer. This is not an exercise where when I collect data, indeed it is not only an exercise that is not required, it is an exercise that can't be done because you are doing an intensive exercise which is to collect data to inform yourself to take policy decisions which are rational and reasonable. There is no question of individually hearing all these people.
There are judgments which have referred to this exercise of publication, inviting of objections and then acting upon it.
No, to that extent, whereas we have given those notices when we went to the survey. I just read to your lordship that can you take volume 2? Volume 2 has that part where we have gone and informed people, but it is not the kind of exercise which your lordship has for an administrative decision making. It cannot be, if I have to survey 97% of the population, there is no question of inviting objections. The very nature of the exercise is different. If your lordship sees that report which I showed, it has to the extent It has to
That
involve
was
people.
for
It has,
collection of data.
yes, that's all. And the collection of data cannot have any natural justice in the quasi-judicial sense. Come to Malas, page 140. To the extent it requires a reasonable, informed, rational thing, it is there. It is very specifically written there. Come to 139, Malas.
Yes.
Volume 2, 139, relevant part at 141. Questions are made at 141. Then methodology means you create households and then enumerators and then supervisors for enumerators. Then you do house listing.
Yes, yes.
And then your lordship sees that page 140 last para, widespread consultations were held with all stakeholders. Their input suggestions were taken into account. There is no other form of quasi-judicial process required for this. I'm saying it's per se not required. And this can't be a ground to set aside or stay something.
Very good.
Second answer, that you do not have a individuation district-wise, as my Lord the Chief Justice rightly says, for the BC population. Well, that is absolutely true. No survey is applied in a state by applying a reservation of X% in district A and Y% in district B. It never can be, it never is. You have to live, because then there is no reason why to say that once you go to a district, you can also say that why don't you have a differentiation of individuation of taluka-wise, region-wise, colony-wise. These are always averages. It is always an average. It's an idea that the total population of a state is broadly X, Y, and Z. And we must mirror that X, Y, and Z in our policy making and our targeted incentives. If your lordship were to apply the test that ultimately the level below the state is district, then the level below the district is taluka, the level below the taluka is a block. There are wide variations. You will never be able to implement because you are doing a broad-based thing. And here, the pluses cancel the minuses. It's the average which works. That's the only practical way for every survey. And any survey, well, no other survey has ever been struck down on the ground that you do not do an individuation of district-wise. That is number 2. These are grounds which are, have to be 2 plus 2 is 5, so perverse, unreasonable, and ad hoc that your lordship can state. Then, the third point, Gowlie's case, come to para 13. If your lordship were reading, wherever your lordship were reading it, come to para 13, SCC page 85. On the face of it, Gowlie is in my favor because it allows me, so long as I follow the procedure of Gowlie. I'm sorry, before that I must say one thing, my apologies. Gowlie's 3 learned judges. So there are 2 submissions. First submission is, please don't read Gowlie as going over and beyond and in addition to the boundaries of either Indira Sani or Janit Abhiyan. Indira was 9, Janit Abhiyan was 5 judges. So
but
as my not putting
Gowlie judgment also considered Indira Sani.
No, they did, Malad. I'm coming to the actual. They had to, Malad, because Indira Sani is binding everywhere. Now,
yes.
My point, I have 3 answers to Gowlie, Malad. Gowlie, answer number 1. Gowlie can only be an implementation of Indira Sani and Janit. It cannot be laying down new law beyond and higher than or different from these 2 judgments. One is a 9 judge, one is a constitution bench. So please read it harmoniously. Number 2, if you read Gowlie harmoniously, then there cannot be a bar in panchayat elections. Because Indira Sani says there cannot be a bar, Janit says there cannot be a bar, Justice Bhatt and Justice Sawant quoted, which I read to say there can't be a bar, absolute bar. Whether it is valid in a particular case, yes, but there's no bar. Now, Gowlie says, now the third point of Gowlie, that you cannot have it unless you do the 3 conditions. To put it in a reverse way, Gowlie is saying you can do it, provided you follow 3. I hope I'm clear, Melissa.
Yes.
Now, what are those 3 conditions? That's exactly what I've done. In Gowli, it was not done. Gowli says you can do it. You can reserve beyond 50 provided you do these three. Be that as it may, it is indisputable that the triple test conditions required to be complied with by the state before reserving seats has not been done so far. That was the problem. Now, what was that? One, to set up a dedicated commission to conduct contemporaneous, rigorous empirical inquiry into the nature and implication of the backwardness of social bodies. I hope my lord is clear, Maris.
Yes.
That is the fatal flaw in Gowli, not in my case. Number two, to specify the proportion of reservation required to be provisioned local body-wise in the light of the recommendation of the commission so as not to fall foul of the overbreadth. I have not two, but I have got three, Malas. The original data collection, the one-man commission, and the expert group, headed by a Supreme Court retired judge. Third, and that committee has I'm not talking of Supreme Court judge, I'm talking of real, genuine experts, worldwide known. Piketty, John Raj, Nikhil Dey, very well-known, eminent people. In any case, such reservation shall not exceed aggregate of 50% reserved in favor of STs taken together. In a given local body, the space for providing such reservation may be available. Now, Malas, this means, can it mean that your lordship has a bar on 50% above? Then there is no Indra Sahni and Janit. I hope I'm clear, Malas. Gowli cannot be meant to say that if you comply with the first two, you still have to be within 50.
But we can't interpret it.
But your lordships can interpret it harmoniously with Indra Sahni and with Janit, Malas. Your lordship is to interpret it harmoniously with Indra Sahni, which I have read, with Janit, which I have read. Otherwise, it would mean that after Gowli, there is an absolute restriction permanently. You can't exceed 50%. Just see the last sentence, Malas. See, what was the purpose of Gowli? See the last four lines. Admittedly, the first step of establishing dedicated commission to undertake itself remains a mirage. I'm very important, my lord's query. My lord's read that last part.
Yes.
Admittedly, the first step of establishing a dedicated commission to undertake a rigorous empirical inquiry itself remains a mirage. To put it differently, it will not be open to the respondent to justify the reservations for OBCs without fulfilling the triple test. The triple test is simple. A, collect data. B, have an expert commission. C, normally stick to 50%, but demonstrate by reference to 1 and 2 that you need to exceed 50%. Otherwise, it will make a mockery of the entire law. Your lordship will not read something rigidly in a manner as to be inflexible. And this is matter of and last, I'm sorry.
Yes.
Last point on Gowli is this the kind of clear 2 plus 2 error into 5 which will justify on the threshold without pleading the final hearing a stay? This is a matter of argument and interpretation at the highest. At the highest, your lordship needs much more than that after all the exercises done by a unanimous state government across the political spectrum in legislature and executive. Your lordship has the power of quashing it. Of course, your lordship does. That is very different from saying that this is so egregious, so blatant, so one-sided, so clearly ex facie 2 plus 2 is written as 5 or 4.5 that your lordship should be able to state. Those are my submissions. I'm extremely grateful.
Yes.
I'm extremely grateful. The election schedule has been declared, I am told, on 29th of September. That's the last point. I'll take a minute on. That paper will be handed over by Mr. Siddhi in volume 4. Please keep the page close to volume 4. Which page? Well, sir, that may be a separate piece of paper otherwise. The schedule is on 29th of September. That's the last reason I'm saying your lordship does not normally interdict a schedule. It's a all-state election process. Again, nobody is saying that your lordship doesn't have the power to touch it. But Malas, your lordships will require something very special and very grave. As I said, patent illegality on the face of it. 2+2, I gave the example. Otherwise, your lordship does not interfere with the election schedule notified on 29th of September. That schedule has been handed over, I hope, by Mr. Six. Mr.
Yes.
Siddhi. That's the last point. I'm very deeply obliged. There are any number of judgments, your lordship. No state of Goa may be handed over. You can't interfere once Malas.
Where is the notification of this schedule of elections?
This one, Malas, 29th September, which is handed over, I think. Subject to correction by the AG's office, Malas. That is the one I have got. 29th of September. It says, annexure to notification dated 29th September. The actual notification may be handed over by my learned friend there. This is actually only the annexure. My lord, this is right. This is only the schedule.
Item number 24. Well, in item number 24, we have challenged the notification and that schedule.
That's all right. I'm not saying.
There's no gazette. The law requires it to be in a gazetted form, the notification. This is just a schedule.
And Malas, it's well known, I don't need to cite case law. State of Goa and many other judgments open it. 2021 8 SCC 401. 2021 8 SCC 401. Three learned judges speaking to Justice Nariman clearly say that a lordship will not interfere once this process is notified. The relevant para is 68 and the sub para 68.1 onwards in that para. 68. And this is related to municipal elections. I'm deeply obliged.
Hey. Learned AG, is it notified this schedule?
Should be notified, my lord. I'll bring it to your lordship. May I have it tomorrow, my lord? I'll serve.
Okay. Give it a copy. Give a copy to us.
I think it's not yet, my lord. I'll produce tomorrow, my lord. I think, my lord, it is gazetted because that's what I have it, but I found out, my lord, that the gazetting is also there. Gazetting is also there of that, my lord, of that notification. Gazetting is there also. Gazetting is there. Yes.
I am appearing for the state. I am instructed to appear for the state. May I make my submissions? Just 10 minutes I'll take. I'll not take much.
It is not yet over. Burma is continue tomorrow.
So this is the notification. And secondly, after that, that 27th March 2025 bill passed by the Legislative Assembly sent to the governor. Thereafter, the plea is being taken that it's a deemed consent. Whether that has been notified as a law,
I'll find out about that. That I don't have.
Nobody knows about it.
How is this a notification?
No, we'll conclude. We have already concluded. No more arguments on interim prayer.
I'll just take 10 minutes.
In that case, my lord,
I'll not repeat. I adopt the arguments of Singhvi. I'm also appearing for the state.
Sorry, Wonder. This is only for one district too. And he's giving for each state, each district separate.
As it కాదు 21 6 SCC 198 క్లియర్ ఉంది ప్రజలు పబ్లిష్ చేయాలి సారీ విడ్రా చేసుకుంటున్నా వాడు
That is a valid correct. I wanted to.
Okay, 6 SCC.
So, Learned AG, apart from Mr. Singhvi, you are representing the state. Other councils are also.
Yes,
No,
I'm.
and my lord, Mr. Verma is there, my lord. Three of us are appearing for the state.
I'm appearing for the state.
Yes, yes, please do.
My lord, we'll
Please
make
it short because we have.
My lord, I think, my lord, it should be appropriate, my lord, if your lordship should continue for tomorrow because other friends are also there. My lord, I might take 10 to 15 minutes. My lord, the state need to be represented by the state, by the office of the state.
But there will be no end to it. We have heard the whole day.
No, my lord, your lordship, not that, my lord.
It's not the final hearing.
I'm counting heads, my lord. Your lordship, please, we have 2 or 3 councils on the other side. My lord, it's the state which is important. The state needs to be heard by more than those people also. Because, my lord, what they want to do is they want to put a spoke in the election. My lord, we have to clarify to your lordship that that spoke which they are trying to put is not correct.
We have no objection, my lord, as long as the state doesn't take further steps on this issue. The state needs to be heard. That's a fair statement by the learned AG.
About today and tomorrow, there can't be any other.
That's what exactly. That's what the learned AG.
Notification is already issued.
It is not issued. Sorry,
Such a
it's not a notification.
First time when the matter had come up.
My lord, apologize.
If that's not the way
Apologize.
proceedings are. Making a point, it is up for us to appreciate and do further hearing or not. Let him say whatever he is saying.
So tomorrow, my lord. Because, my lord, that's the notification. If your lordship will please to see insofar as the notification is concerned.
Lord, I would like to add only one sentence. First time when the matter came up.
No, you don't add now.
No, learned AG. No, learned AG has said. Learned AG assured nothing will happen till today. But much water has flown up till today.
I did not say.
He did assure. He did make an assurance.
So we keep it at 2:15 tomorrow, with the understanding that you and Mr. Ravi Verma would be arguing on behalf of the state, not repeating the argument what already said. And
not a word will be repeated. I'll simply adopt Dr. Singh's argument.
And then we'll see some reply from the petitioners if at all.
Where the petitioners are not being infringed a single fundamental right.
How can you say that?
And they have been filed the frivolous petition. We will demonstrate along with the quantum of law of unaffected court before your lordship.
Complete petitioners will hear at the final hearing stage.
No, after completion of the state, my lord, after completion of the state, because single petition would not be sustainable before your lordship.
Complete petitioners, complete respondents will hear at the final hearing stage. We had good consumption of
one request,
one request from state side also.
Submission with great respect to this honorable court, my lord.
One request.
Primary issues are there.
2:15 tomorrow.
One request. One request. I think the learned AG made a fair statement, my lord. The state needs to be heard. They are entitled to as much right of hearing, if not greater right of hearing. But let them not make it further steps on this issue.
No, Malus, we are objecting completely.
Notification is not been issued.
Otherwise, Mr. Verma and Mr.
The nomination process starts,
this should not be an excuse to